My lord,
My
what
lord, may I
correction?
mention? I mentioned one listed motion. But listed motion.
Listed motion.
My lord.
My lord, correction is required. What happened in the presentation from instead of group 1, group 5 has been written. File has come. I have mentioned before your lordship, my lord, allowed the mentioning when file has come.
Group 5 is on Tuesdays.
No, my lord, it is group 1 matter, correction of record before the UD department.
You have
I,
mentioned group 5, what can be done? Group 5 are only Tuesdays.
my
That's
lord,
as per your request.
my-
Of the bar. Now it's
only correction, my lord, grant.
today it's appearing in the list.
No, my lord, not appearing. I talked to.
Cannot be taken up today.
No, kindly keep it tomorrow, my lord, under the to be.
My lord, may I pray your lordship's leave to move this matter on Monday? The urgency is 16. The order of demolition has been passed under West Bengal Highways Act. 24th, I preferred an appeal. During pendency of appeal, they have intimated they are going to start the demolition work on and from Monday.
On and from
Monday.
Monday. Which
Lord,
item?
But this is, I'm going to, my lord, praying for leave to move it on Monday.
If we move on Monday, all right.
My lord,
Content.
মাই লর্ড, আমরা গত 20 ফেব্রুয়ারি মেনশনিং এর স্লিপ দিয়েছিলাম, কিন্তু আমাদের ইন পার্সন করছে বলে কিছু সার্ভিস প্রসেসে তাড়াহুড়ো করতে গিয়ে অসুবিধা হয়েছিল। তার জন্য আমাদের সম্মতি ছাড়াই আগের আইনজীবী মামলাটি তুলে নিয়েছিল এবং আমাদের কাছে টাইটেল শুটের ডিগ্রি আছে। বিএলআরও বিবাদীদের নামে মিউটেশন করেছে অমান্য করে ডিগ্রি, আর এই ডিগ্রি হয়েছে 2023 সালে, কিন্তু তার জন্য কোনো আমরা সুফল পাচ্ছি না এখনো পর্যন্ত। বিবাদীরা হুমকি দিচ্ছে।
ওকে নোটিস করেছেন?
হ্যাঁ, করেছি, এবার প্রপার নোটিশ করেছে। এই সার্ভিস অফ এফিডেভিটটা এর সাথে অ্যাটাচ করে দিয়েছে।
পরে ফাইল করবেন, আপনি শুধু
May I permit to mention for one matter under the heading, the matter already in the list under the heading fixed matter, item number 197 and 198.
the appearing in the daily list.
Yes, Lordship.
What do you want?
For a hearing, Lordship.
Will be taken up.
Yes,
So, Lordship, we have to give the interim extension.
your lordship's kind leave.
Extension of interim order will be expire on tomorrow.
Interim order will expire tomorrow.
Yes,
All right,
Lordship.
extension of, please mention extension of interim order. Please mention when it is expiring, then hand over the slip.
Seeking your lordship's kind leave to mention a matter which I had already mentioned yesterday. Your lordship was very gracious to allow it. Lordships, however, upon filing, because this was a matter that is a changed roster matter, previously appearing before Her Ladyship Justice Amrita Sinha, wrongly filed before Her Ladyship's roster. But your lordship, my instructing advocate tells me that your lordship's court officers have informed in their wisdom, and they are given to understand that it can only come up in the monthly list of April. Lordship, the only urgency that I'm attempting to canvass here, your lordship,
All right, hand over the
responded,
slip, please.
your lordship,
Yes.
just in March, anytime in March, your lordship.
Yes,
Grateful to your lordship.
on the list. Number 1. What is system?
This is direction for file a report regarding
The Coron is my lord is on the way, man. Tarok Coron.
the last occasion, my lord. It has informed neither the plots have been utilized nor position taken.
Yes,
Mr. Tarok Coron, my lord, is on the
And this is
way,
the-
my lord.
he's on the,
Way, my lord.
where he is now, on the way is one thing.
And he's in lift, my lord. Lift.
If all it's pass over. Short pass over. Yes. Call the next matter. See to একটা সময়।
In the 4. The 4, I have got the petition.
But I appear on behalf of the private respondent.
Yes.
So kindly see your lordship's last order.
Yes, demarcation made.
Encroachment is there.
Not in terms of your lordship's direction.
That's the different thing. Demarcation made, yes or no?
Yes, demarcation made
Not in terms
your lordship's direction.
yes. Yes, what is the violation of the direction?
My lord was, my lord, directed my lord to put up a my lord the board on the side of the my lord the plot. And that has not been.
Are you canvassing for the other side?
No,
You are notified.
I am-
You are present.
Because
I will-
your lordship was
I will consider that. Let others come, I will consider that. So you are present.
my lord.
So you are not canvassing the case of others. That I will consider. Yes, yes, where is the state?
The state
State led by Mr. Gali, my lord.
Yes, where is the report?
This is the report, my lord.
Yes.
At page 3, my lord. দিচ্ছি দাঁড়া।
নামটা লিখে দিন।
Other side.
I am handing over, my lord, one copy to the petitioner, my lord.
আর একটা কপিটা দিয়ে দিও, হ্যাঁ, জেরক্স করে দিয়ে দিও।
এখান থেকে দেখে নিন। সমগ্র পিডব্লিউডি রোডের নয়নজুলির উপর দখল হয়েছে। ইটা হচ্ছে সুবান আলী খান।
অন্য দুটো জায়গা দখল।
এটা ওরা ডিমার্কেশন করেছে, যা রিপোর্ট আছে তাই।
কি সুন্দর।
44/20.
The there is no question of adjudication at that stage.
So if they have to proceed, they will proceed.
So let them proceed.
Did not indicate alert, indicate that they should proceed. If they have to proceed,
Why,
they
Mr.
will
Bose,
proceed.
you want the encroachment to remain.
No,
You also want encroachment to be removed.
no.
Grateful, my lord.
Lordship keeps it on the ninth.
Mr. Bose, you need not be swayed by the fact as to who are the encroachers, whether your petitioner is the encroacher, but you should be concerned as to whether encroachments are to be removed or not, being an officer of the court. So, if prima facie there is an encroachment, let them proceed. Thereafter, you know very well the stage when you have a right to contest, because at all times you are saying that I was not provided with a copy of the report. Inspection was not made in your presence. That is why I tried to monitor this matter from the stage of inspection. So report will be supplied here and now, so that it's upon the learned senior advocate. So your client may not deny afterwards that the demarcation was not made, report was not served. That was the only purpose for which I kept in the to be mentioned hearing. Ashun, let
My lord, one mentioning, please. One mentioning, kindly allow.
This is not the time to mention, sir. List has been called on. You are a junior member of the bar.
My lord, kindly allow.
Yes, Mr. Rai.
But your lordship considers.
Last occasion.
Page 84, this is the final order, which was under challenge in the present writ petition. is
I
under
will
the
consider,
2002 Act.
Mr. Bose, I will consider the matter.
So in the meantime, if they proceed to demolish, because if your lordship will
They-
see, page
they-
84
They
is-
cannot demolish. They cannot demolish
because what your lordship is.
because
said the
Mr.
sentence
Bose,
of
this
your
is
lordship's
a,
order,
this is a,
that
another.
will encourage them to proceed to demolish.
Shall not
and say that
discourage.
High Court has said demolish.
No, I said I shall not feel discouraged,
That
not
is-
encouraged.
That is.
That is why this.
That will be considered.
So that will
encouraged.
no, that will be in accordance with law if they interpret in one
Kindly
way.
do not add that line. If they think they should based on that, kindly
That
do
is
not
why I
add that
said
line.
no. They may find yes, they are entitled to, but during the pendency they will not do. That's a different thing altogether. That is why I said
Coming back
should
to
not
your
be
lordship on the
discouraged.
10th, if your lordship said on the 10th, let them do the demolition after the 10th. Kindly do not add that line.
Last line ta केटे दिन. It shall
Your lordship can understand that.
That will encourage. That will encourage.
It has to be demolished, it will be demolished after the 10th. Just a matter of 10, 12 days.
thank you, Mr. The court felt your presence, Mr. Bose. Yes, Mr. Rai.
My lord, last occasion, this matter, your lordship fixed, as to be mentioned, your lordship asked me to take instruction pursuant to page 31 of the writ petition, whether there is any, my lord, the land has been transferred to the requiring body or not, and not that.
Arun, that was one thing. You have said that was left out. My direction upon you to take instructions whether that plot has been utilized or not.
My lord,
You have said not acquired.
my lord.
Utilized, yes or no?
No,
Not
as per our.
As per my lord, either it should be utilized or not. Well, may I have a copy of this?
Yes.
Please give a copy.
The requiring body.
What is your plot, Mr. Rai?
394.
394.
Yes.
It was vested.
Yes, my lord.
Very well. Very well. My lord, I'll come to that. So this is the case? Page 32. I could.
Arun, what is your paragraph 4? You have said it's not within your knowledge. How can you say so?
My lord, we
Whoever is
have
the
not,
party.
my lord, kind of visualize the thing, my lord. We have not acquired. We have not acquired,
Arun,
we
there
have
are-
not taken
Mr.
possession.
Arun, there
It
are
was a
two
vested
aspects.
land already.
There are two aspects.
My lord.
One is acquisition.
Yes, sir.
So utilization under proper authority of law. Another is no acquisition but utilized. So I wanted to take instructions on whether it has been utilized for any public purpose.
No utilization. My lord,
That you have not stated here. You have stated paragraph.
Very well.
4.
If my lord's
paragraph 3,
contention
your
is there,
lordship, kindly see, we have not, my lord, was not declared as it was a vested plot, my lord.
No,
My lord.
that's a different thing. You have not initiated an acquisition proceedings that was vested. Understood.
We have
But
not.
whether that plot has been utilized, yes or no, even if it is a vested. Say
So
one
far
line.
as
what
our
is the
knowledge
Gitaji?
goes, my lord, there is no utilization.
Who can say whether it has been utilized or not?
We have not acquired. We have not handed over to
Let
the.
the PLRO, let the PLRO
not the
demarcate
PLRO,
that
my lord.
plot. Let the PLRO demarcate that plot and submit a report as to the existing.
And any-
Vested
no, not only
property,
that.
No difficulty.
My lord,
Vested
my lord.
property, no difficulty. Let the PLRO demarcate and file a report as to the existing.
And last
condition.
occasion, my learned friend has said that the railway authority has built a platform there. I have taken instruction. They indeed, my lord, constructed a platform, but that platform is being done in another plot, another moja.
All right.
So let me, if it is not a.
Concerned with another moja, Mr. Kono.
Yes,
please.
not in this, my lord. My lord,
All
your
right,
lordship,
I'm recording that it has not been utilized.
my lord,
This
my lord.
property has not been utilized.
My lord, so far my instruction goes, my lord, para 4, whether the suit clause has been utilized by the requiring body. I have not handed it over to them. If they themselves make it utilized
So it's
by
whose property
somewhere
now? It's whose
or
property
other,
now? It's whose property now, according to you?
it's a government property.
So,
After vesting,
This is the order.
so
Subject to action, my lord.
not utilize that, and you will not be knowing about who has utilized.
in that event, my lord, my lord, I have to take further instruction. I
You don't want to
specifically, I
protect
asked,
your vested property. You don't want to protect your vested property.
my lord, I want to. But, my lord,
That
the
is
thing
why I
is-
wanted that instructions. You should have said, no, it has not been utilized. It's with me.
I specifically asked the department whether this land has been utilized or not. Please let me. They have said such this
You
type
said,
of
I
instruction.
do
my
not know. I do not know whether the requiring body.
And
has
what the
utilized-
vesting order that was set aside by the, and it was held. I have
What is the
added.
vesting order? Please show me the vesting order.
Yes. This is the EA
It is-
bill.
It is not with me, my lord. My lord.
What my learned friend is submitting, it was produced after that.
Mr. Rai, where is that plot number?
Yes, my lord will
60.
My lord,
394.
Where do I get that plot?
Yes, my lord.
32, page 32.
No,
Yes, sir.
not there. In the this
Page
degree.
32, my lord. In the writ application, can you page 32.
Page 32 is the judgment you have annexed.
No, the information to the land acquisition officer by the block level.
No, in this judgment. which
Yes,
you have
yeah,
annexed,
my lord, I have only one copy with me, my lord. Hand over to you.
Please show it to Mr. Karan first,
Hey.
then hand over to
দেখুন।
me.
এলাকাতে নাম্বার কত দেখুন টু থ্রি জিরো 264 আর নারায়ণপুর ইন্টার খতিয়ান was recorded in the name of the transaction the revenue officer that is recorded sought to be rectified the access illegally with the jurisdiction a
No, ঠিক আছে।
and when I find though the appellate have failed to produce the records, tenants claim have been settlements. I find that there is a number of rent receipts showing the payment of acceptance.
This is another thing.
Another thing,
My lord, it's not specifically mentioned anything, my lord.
Yes.
RS Khotiyar number 264, 265 and 230. Namal can takes up
Where
What
is
are
the decree? Where is the degree of the suit?
not the suit. It is estate acquisition 44-2A. It is not
Do I get the plot number, Mr.
Khotiyar. Enter Khotiyar has been considered last.
Khotiyan? Where is the record of rights?
Last portion your lordship find the Khotiyans.
Last portion of
The order which have handed over to your lordship. Now my lord takes up the
I just have a glance, I couldn't find it.
Mr. Rai, I could not make myself clear. How do I know that this plot forms within this Khotiyan numbers?
yes P1 your lordship can turn to P1.
P1.
That is page 17.
Yes.
And P4 is my lord the notice issued under section 11.
Please show me this plot pertains to these Khotiyans. What were those Khotiyans?
RS plot number 394.
Is 264, 265 and 230.
Yes.
How do I get that? Different Khotiyans.
No, this is the order.
Khotiyan number 1940.
394.
How do I know 394 was within those Khotiyan numbers?
Compensation.
This is the order puzzle 6/4/1993, my lord Kali. 6/4/1993.
Which order?
The order I have handed over to your lordship, my lord. Now my lord Kali takes up 30.
31st of January 1983.
EA appeal number 33 of 1972.
Yes. So
Now, my lord,
31st of January.
Yes, my lord. Can you turn to page 32?
Page 32 of the
Writ application.
petition. Yes.
With refers to the above memo, my lord got it?
Page 30.
Memo.
In
This-
reference to the above memo, yes.
The arrest plot of 394 measuring of such and such classification shall be of Mauja such and such has been declared vested to the state of West Bengal under the West Bengal State Acquisition Act 1953. My lord, got it?
Yes.
The said arrest plot number is corresponding to LR plot number 529 measuring of such and such has been recorded in favor of Swadesh Kumar Giri, Rabindranath Giri, such and such, respectively LR Khatiyar number such as maintaining objection case of 562B under 51A1 are not traced out of this office. Attested just copy of the LR Khatiyar number has found and inserted in the LR volume instead of the original Khatiyar. Swadesh Kumar Giri have not produced a certified copy of the miscase number in respect of the compliance of the order of such and the order EIP number such and such. Now, my lord, this was passed, and apropos to this, my lord, can you consider how the state can come forward and say page 29.
Page 29, yes.
Yes, my lord. This is the section 11 notice issued to whom, my lord, can you consider?
Rabindranath Giri.
And Swadesh Kumar Giri. If it is a vested part, assuming, my lord, keeping aside everything.
How could you issue a notice to them?
My lord, in that event, my lord, my lord, I visualize the thing, my lord. My lord, I have to.
Now you visualize the thing.
My lord,
Your officers are giving instructions with closed eyes.
my lord,
Enter freight corridor will be stopped.
Him. And this is the judgment.
the judgment, my lord, I think, my lord, the Khatiyar number is different.
Yeah, he appeal.
Saying you are not applying your mind. Please see your officers. Page 32. Perhaps your officers also, while giving these instructions, did not go through the writ petition. They noted this EA case number and only observed that they failed to produce the certified copy. This is the certified copy. They also must be having the records.
11 notice was issued. You
They did not recognize them.
Since they have issued 11 notice, my lord.
Yes.
So
in the records, their name was there. So you could not have treated them to be a vested property. If it was prior vested, there was no occasion on your part to issue the notice to them.
So in that event, if there is no vesting, so it is his land, the petitioner's land, the land which we have not acquired. In section 4 notice, we tried to acquire the land
Mr.
394.
Mr. Koron, there are several matters which are coming up. You have utilized without initiating any acquisition.
And now the question is
That
whether
is
we have
why-
utilized it or not.
That was
My
the
lord,
only question.
my lord,
You have kept it
My lord,
blank.
1 week time be given, my lord, to me, my
Yes,
lord.
so
Let
you
me
should
come,
You should have said it at the beginning.
my lord,
It
my
would
lord.
have been ended within 1 minute.
My lord.
You said it's
Right,
vesting,
right.
such and such. I have not handed over. Requiring body, I am not aware.
No, I have gone, I have go through this, I have, what I have submitted before this, depending on this instruction, my lord. My lord, let me come back to the
Papers
first
are
instruction, my
directed
lord.
whether it has been utilized. So it's
And
seems
your
that they are
lordship,
trying
your
to.
lordship knows nowadays they are heavily engaged in, my lord, the SIR.
That's neither
My lord,
That's neither
I am not
here.
giving any excuse, my lord.
Very well.
It's
The
there.
land has not been utilized. Allow me to take possession of the
No,
land.
my lord, no, my lord, let
The
me come
entire
back,
freight
my lord.
corridor will
No
be stopped.
passing order, my lord, let me come back.
Yes.
The fresh instruction thereafter.
The entire freight corridor will be stopped.
Specific
The
instructions.
status report prepared They are taking because Mr. Rai now.
I'm working in the field. I know I know the situation, how the
Photographs, we
officers
kept
are.
the record, my lord, the photographs.
What I will do with the photograph, nobody knows. You have taken the photograph of which plot?
Very
Maybe the rail line
adjacent,
behind
very
your property at.
that much courage
Lord, one more thing
the petitioner does not have.
one more thing I'll beseech your lordship. Your lordship, kindly tell to Mr. Rai hand over the copy of in my cost, I'll get it here.
No, not to cost.
Here's my
It is a BLR office.
No, Mr.
down,
Rai
I'm
only
going.
asking, please
That I'll
supply
supply.
the copy.
In many matters, I help him, Lord.
Mr. Rai, Honorable Advocate,
Sure.
the Mr.
My lord, I am for the petitioner in the petition number, my lord, 1190 of 2026. My line
Yes, why it is appearing today?
my lord directed.
Yes, what happened? Who is the proprietor?
Yes, what of the interest amount has been deducted?
No,
By the way,
no difficulty.
yes,
No, my lord,
18
the,
lakhs, it figures have come to
Which is?
18 lakhs.
the
18
bottom-
lakhs. He,
No,
he
I am
is
happy. My lord,
willing to pay 22 lakhs.
Yes,
My lord, I am happy of the amount. So
you are
far,
happy with the amount. Right.
my lord, the only
He will pay.
my lord, the only my lord, the kindly see on last occasion I filed the undertaking. My lord, the one for my lord, the directly my lord, when receiving the retirement benefit within 7 days I will pay. That is the lordship's undertaking
Yes,
paragraph
you have stated that in the
paragraph
undertaking.
5.
Yes, sir.
Yes, that is there. So now with regard to the amount,
Amount we have
that has also been
I see.
finalized, nothing. So
nothing. That is true.
as soon as the retire gets the,
Yes, but kindly direct the DDO to send the money to our account.
Why?
My lord, he will not pay, man. He will not. Yeah.
Of course,
Statement is-
my land is
difficulty.
my land is
What is the difficulty? Because you will get and pay.
no my
Instead
my
of that, I will direct them
my-
because they can deduct.
my
Under
respect.
the statute, let them deduct and pay you the balance.
No,
DDO is duty,
my
lord, to
respectful
pay, man.
submission only things on undertaking I give in the my lord. My lord, the 50% amount will be deducted. I have no objection to that. 50%, my lord, the within certain time should be given. That has not been allowed.
Not a
That is the
certain time.
He is going to retire by this month, my lord.
and apart from that, my lord, only one things, my lord. If your lordships kindly appreciate the my landed property, who is the mortgage property,
That's a separate loan, my lord. He's,
no kindly. That has been allotted to third party. I have raised the objection to the person.
For that you proceed, I give them liberty to deduct that, pay it to balance you will be getting. Ashun. আচ্ছা ওটাকে ঘুরিয়ে দিন। Yes.
Unauthorized construction of the minor temporary in temporary nature of stalls and minor
Where?
minor in front of my residential premise.
PWD road.
No, it is unauthorized occupant act.
Minor, this is an act of 1962, minor. Minor, this is the application.
No, encroachment upon which property?
Minor, encroachment upon minor plot number 192 and 193, minor.
192 and 193 belongs to whom?
Minor, 193 is the minor canal and 192 is the canal part. And minor, I am residing in plot number 201, minor.
Yes,
And-
Mr.
and
Mahato,
my
what is your submission?
My lord, he had
Consider this, take steps in accordance with law.
in my lord unauthorized occupant acts, my lord. Then
I'm not saying any act.
then my lord. Yes.
I'm not saying under any provisions.
Any provisions, my lord.
Uh, who will be the appropriate authority?
Minor, respondent number 3, minor.
District magistrate, what they will do?
No, SDO.
Have you have you made any representation to the
No.
SDO?
Yes, minor.
Where? SDO has not also been included as a party.
SDO is the authority.
Minor, but minor, under the Act of minor 1962, minor, the collector is the,
1962.
Collector is not the DM. A DM and SDO.
no, minor, if your lordship, minor, kindly allows me, minor, to incorporate the minor, the
You have not given any representation to the SDO also.
SDO, no representation.
minor, in that case, minor,
I
kindly.
give you liberty to file a representation. If that is done, they will.
That-
Yes,
consider.
minor, that's okay.
The petitioner alleges
Yes, my application. This is my affidavit of service. No, according to me, it should be decided by way on affidavit. I tell you, Lordship, why. Because earlier I moved a writ application before this honorable court, entirely praying for compensation.
Paying for
Compensation. Now, acquired. Now,
check.
Act 2. Act 2 of 1948.
Act 2 completed, award declared.
Yes. According to them, the award is declared. Now, according to further, they have said that this has been deposited with the treasury. This is number one. Number two, they have said the amount award declared, but no document is traceable. So that is the reason, my lord, I
have not got the compensation amount.
No. Not only that, earlier coordinate bench of your lordship has said that if it's found that I have been paid, then criminal proceedings should be initiated. That is my lord, the apprehension. So that's why I'm praying, my lord, let there be a direction for affidavit disclosing the document.
If the amount has been paid,
then my lord, criminal proceeding will be initiated against me for moving this application. Earlier moving this application. That is my
false statement on oath.
Yes. So, my lord, that's
the right direction, Mr. Pan.
But if
matters,
yes,
I want
I fully bow down to your lordship.
Because I also want
I am not
positive statement on affidavit stating whether he has received or not. If on document something is found.
Yes, that's why I am praying before lordship. Let there be a direction for affidavit because no document has been annexed with this.
Have you stated on oath that you have not got compensation? Where is that?
Yes.
But you kindly gone through the page 30.
When the acquisition proceedings was initiated?
68, 69, I understand. 68,
69.
Yes.
What was your age at that point of time? Not your age. The deponent's age.
Deponent is my predecessor.
Deponent. Here, affidavit was affirmed.
Oh, he was, but I don't think that he was born at that time or no. Because this is by the father's predecessor interest.
Now, where have you stated that neither your predecessor received the compensation nor you have received the compensation? Which paragraph?
Page 30, Lordship, kindly.
Yes.
Para 7.
Paragraph 16. Paragraph 16.
Lordship 30. Page 30. Paragraph 7.
No, paragraph 16.
Paragraph 16 of my petition. Paragraph.
We are reading of the alleged order.
Yes. It appears that neither the predecessor interest of the petitioner.
Mr. This is an interpretation of an order. Positive statement that I have not received the
Lordship,
compensation.
that's why, Lord, I submit the order. Page 30. Page 30, Lordship, kindly gone through the 7. Paragraph 7. Of the government of this special official.
Paragraph 7.
Lordship. From the period of the award of this the found the vice award number.
No, that is the finding. Mr. Pan, where have you stated that you have not received the compensation amount in the petition?
Because I tell you, Lordship, earlier.
Have you stated? I have not stated. File a supplementary affidavit, then I will call for affidavits.
My lord, I will file a supplementary affidavit. I will file because I find
the basis of your knowledge.
Yes. Because otherwise, I have said that it appears from the record itself, from the speaking order itself.
That's a vague statement, Mr. Pan.
No, my lord.
You have to, whether you have received or not, that's within your knowledge.
Yes, that's true. But what I am on is this, my lord. Kindly have a look at it. Kindly visualize one thing. My lord, their case is this, that they have deposited with the treasury. Treasury deposit is not a valid deposit at all.
I will go to that.
Yes.
You have not received the compensation.
I will file a
there has to
supplementary.
be a statement.
My lord, I will.
And who was the owner? You or your predecessor at the
my predecessor.
Your predecessor is living now.
No.
When he died, you have to disclose the date of death of your predecessor in interest and when you came to know and how you came to know. These are the 3 essential statements on affidavit you have to make by way of a supplement.
But I have said when he died.
Not on,
Predecessor, my predecessor. In the year on my lord,
allow me to make myself clear, then you will
22.
suffice. So at the point of time when it was requisition, you were not the owner.
No,
Your
no,
predecessor-
requisition,
When it was requisition,
yes.
then notice under 4(1)(a), then publication of award. You are not the owner of the property. Your predecessor was the owner of the property.
Yes, my predecessor was the owner of the property.
You are not the owner of the property at
No,
that relevant
No,
point of
no,
time.
no.
So at the time of declaration, whether your predecessor was living or dead or he passed away, that's one of the most important thing. When that award was declared and the deposit, whether your predecessor was living or dead, and how, what is the basis? Because now you will file an affidavit. So you must disclose what is the source of your knowledge that your predecessor did not receive or the compensation.
That I have
Also
to,
you have to state.
other part of the query, my lord, I can hear and I can satisfy your lordship, my lord,
Not
because.
from the bar, not from the bar. Some
My
responsibility.
lord, my lord.
Has to be
Kindly direct them. Kindly direct them, my lord, I will file a supplementary.
After some argument, Mr. Pan of your knowledge.
Lordship.
I'm for the
Yes.
petitioner, my lord.
But I am for the state response.
My lord, page number 22. The date of it to file the application, sir. Page number, my lord, 22 of my petition, my lord. This is, my lord, record of rights. My lord, if particular agricultural plot of land has been allotted and settled in favor of the petitioner by the state government, my lord, by way of patta.
You want patta?
My lord, in 2022.
Under what provision of law?
My lord, section 49 1A of the WBLR Act 1955, my lord.
So how it is maintainable here?
My lord, administrative inaction, my lord. I have made representation, my lord. Kindly consider that, my
The petitioner has sought for service taken on record. Yes, next.
Item number 10.
My lord, I am for the state.
Yes,
Sir, I am for the read petitioner.
yes,
I am for respondent number 6.
yes.
My lord, I'm placing the nutshell of the case. My lord, 2000,
Challenging. What are you
I am
challenging?
challenging that after the final execution, before the execution of the renewal, I purchased already the stamp paper. They received 2005. My lord, kindly come to page
Just like it.
once
My
more,
lord,
my lord. Page 4. Page 4, my lord, of the REIT application.
2012. Rules and
My lord,
regulations.
my mining lease deed has been accepted by the district magistrate. I have purchased the stamp paper. I have deposited 2,500 for the security, everything.
When have you deposited that?
2012.
2012, within the time. Now, my lord, the question, before
Now
registration,
they have not registered.
no, what happens, my lord? Before registration, they suddenly point out that the plot in question is a bridge buffer zone. If it is
What the question is?
bridge buffer zone, that is something a bridge is still situated. My lord, I have expired 5 years. Then my renewal was granted and approved by the DM. And how this question come in respect of the bridge buffer zone? My lord, what happens, my lord? I made an application. On the basis of that, I demarcated some plots. They kindly transfer my plots. My lord, come to page, the annexures.
What
Which
is the order under challenge? Please kindly come
challenge
see
is that, my lord, the question arises from the authority that since it is a bridge buffer zone, we cannot register.
Are you challenging any decision of the authority?
Not only that, I am challenging the decision as well as the view. My lord, come to page, my lord. My lord, come once more. For a moment, my lord, I am placing the notification.
Sir, I will come to that. Please take me to the order which is under
Yes,
challenge.
yes. My lord, come. My lord, I made an RTI. My lord, come to.
All right, please give me
Yes, my
please
lord.
give me 2-3 minutes.
I'm giving you.
My lord, may
Give me
I
2-3
place the
minutes.
report, my lord?
My lord, they have received. First of all, they have approved the final lease deed by the DM. Then I purchased the stamp paper and final lease deed was prior to execution. They received 2,500. That is for the security deposit. Everything. No whisper that the plot in question was a bridge buffer zone. Now, my lord, if it is a breach buffer zone, they can't issue the environment clearance certificate. Not only that, they cannot, my registration cannot be completed. But there is a provision. My lord, এটা দিন তো জজ সাহেবকে জজ সাহেবকে দিন। My lord, kindly see, the rule may be called with the West Bengal Sand Mining Transportation Storage Cell 2021. Now, my lord, come to page and kindly come to rule 6.
Yes.
Sand mining plan, sub rule 3. The said mining plan, as specified under rule sub rule 1, shall be reviewed from time to time. If it is a plot in question is a breach buffer zone, I am compelled to file a revised plan, and they will accept it. My lord, what happens, my lord? I have pointed out there are 4 plots still remaining and it is a potential zone not within the breach buffer zone. My lord, they are not accepting my proposal. My humble prayer is, my lord, when the plot in question arises as a breach buffer zone, therefore I will not get it. But under the rule 6, subsection 3, I can review the mining plan, which can be accepted. And then I pointed out, my lord, come to page for a moment, my lord. Yes, my lord. Come to page 29 of the lead petition.
Yes.
And come next, my lord, 30. I have pointed out these are the same Monja. My lord, these 4 plots are still lying vacant, and not only that, they are without the compound of the breach buffer zone. My lord, my humble prayer.
Participate in the e-auction. Participate in the e-auction.
My lord,
Get
after
that property.
my lord, what happens, my
Now
lord?
the new policy has come in.
Yes.
Now the new policy has set in.
Whether I can.
Your right accrued from 2012.
Yes.
You have approached in 2026.
So what?
So,
No, my lord.
participate in the e-auction.
No, my
Where
lord.
is the difficulty?
Whether the
Participate in the
question,
e-auction.
whether I can review under section sub-rule 6 and
Show me that your right accrued under this rule. Your right accrued under the old act.
2002 rules.
yes,
It's
why not?
Repealed in 2016.
No,
Repealed. So your right did not accrue at
can't
that
be.
point of time.
My lord, come to rule 62(2) of the West Bengal Mining Rules 2016. Yes, my lord, I am reading.
2016 mining rules stuff.
62 repeal. Can you take the
You kindly take my.
Yes.
62 to repeal? The West Bengal Mining Rules 2002 years repeal. Notwithstanding such repeal, anything done, any action taken, or any person or stated under the said rule shall be deemed to have been validly done or taken or started as the case may due for the corresponding of the previous of this rule. And my lord, 61 proviso provided that if the application on the basis of the grant order or letter of intent may be granted equity the allotment and the person is the shifting of the mining lease may be considered and in the consequence of the money. Therefore, under Rule 62(2) of the West Bengal Mining Rules 2016, I am entitled to get. Why not? They have accepted my final lease deed. I purchased the stamp paper. They have accepted the security deposit. At that time, no whisper of the lease buffer zone. Why they have accepted? Is it
the grant letter, grant order,
Yeah,
the
grant,
LOI?
grant order means, my lord, until I have stated in the writ petition, my lord, kindly say,
Please show me the grant order or the LOI
my lord, grant order,
requiring alteration of the applicant's position.
yes, my lord, kindly say.
Please show me that.
No, no. My lord, all right, for a moment, my lord. No, no, the grant order था याद है ना
রিনিউয়ালটা যে অ্যাকসেপ্ট হলো সেই অর্ডার
The orders in terms of
my lord,
61(1).
what for a moment, my lord.
ম্যানেজ করেনি that is not a part of the petition.
No, no, my lord, it is previous one. My lord, I have a document, my lord. Kindly say document.
Please file a supplementary affidavit.
All right, my lord. I will supplement, file a supplementary.
After some one month list of March.
Immediate list of
After a week will be in March.
Oh, my lord, I am not.
Because only one day working day left in February.
Lord, I am for the petitioner, my lord.
Yes.
Last petition, the matter was withdrawn, my lord.
Withdrawn.
With liberty, my lord, your lordship's.
I am appearing for the
File
private
fresh
respondent
application, my
number
lord. My lord, in
Now with correct particulars.
yes, my lord.
one of the correct particulars, maybe, but one of the statement was not matching with the one of the records. Let my learned friend start. Thereafter, I shall show his specific
We
statement.
will be drafting a written statement today in the chamber.
No,
Written statement. Treating this as a plaint in a civil suit.
no, his representation, he is in front of the Maladi PWD land. I am.
Seems you are taking steps to draft a, you are sitting in your chamber to draft a written statement. First 6-7 paragraphs, usual paragraphs. Yes.
My lord, my plot is 8214. My lord, in front of my plot, my lord, private respondent constructed a building on the PWD land, blocking my egress and regress, my lord. That is my grievance, and I have given, my lord, representation before the authority. Page 20, my lord. Kindly, my lord, direct to dispose of the same, my lord.
Yes, yes.
Page 20, my lord, annexure P3.
Page
Twenty.
20. Yes, Mr. Ghosh, what is your submission?
Now, my lord, according to him, my lord, he got the title by virtue of this deed.
I will decide the title. Yeah.
No, my lord, what I am on, my lord, kindly comes to page 18.
1-8.
1-8. My lord, the 4 plots has been mentioned. Out of 4 plots, he purchased, my lord, the 1.23 acres. Now, the next page.
Have you encroached upon any farm?
No, my lord, I am coming. I am not in.
Directing them
No,
to
my lord,
decide.
what? My lord, kindly comes to my page 19. 19, my lord, plot number 8214 is a big plot. 2 acres, 5 decimals. My lord, he is the owner of 37 decimals.
And you are the owner of 67.
No, my lord, he is not the full owner. Now, my lord, what I am,
You have managed the other co-sharers.
my lord, another co-sharer, my lord, also, my lord, earlier filed a writ petition.
You have managed him now.
No, my lord, that proceeding is pending before the SDO concern. Now, my lord, what I am on, my lord, in the deed, it has been written that all these plots he purchased in the Purvangse, to each side. And my lord, kindly see the Moja map, where the, my lord, the road is.
He do not have any title.
No, I am not.
Go in a suit challenge.
No, I am not. I am not against his title, my lord. He claimed that the, my lord, in front of this PWD road, I am blocking his egress and egress. So, my lord, he has to, my lord, establish that he is residing there. This is, my lord, the undemarcated property. Others co-sharers, how, my lord, he is claiming. My lord,
That is why I am asking you have managed the other co-sharers.
no, my lord, one of the.
Permission of the other co-sharers to encroach upon
No, my lord, my lord,
the
এমনি মানে kindly Sushant Haldar.
Yes.
Sushant Haldar মানে the Khotian number 8052. Also against same allegation, same representation against me and others. Mala that proceeding is pending before the mala the SDO.
Another proceeding will be pending before the SDO. Another proceeding will be initiated.
Mala so in that
The
event mala
SDO will stop both this.
yes. Mala otherwise mala in
But
that
he has
That prayer you
constructed,
made there.
my lord, he has
Once it
constructed
reaches
long while.
the SDO, let that stage be reached here. Then you make a prayer, both to be club.
না কোন ক্লাব করে দিলে খুব ভালো হয় তাহলে আমাদের
করবে তো ক্লাব করবে
ক্লাব
একসঙ্গে শুনে
একসঙ্গে ছিল।
The anything the You, when I was dictating the order.
Get from us.
Yes. Yes, Mr. Chaudhary.
After being declared as a H1 bidder, Lord, I could not deposit the annual sand premium 50%, Lord, within time because of being indisposed of cardiac blood ailment. Now, Lord, this gave me a further opportunity. But Lord,
Gave further opportunity.
they gave further opportunity. But Lord, I was not apprised by my family members because Lord, I was Lord, suffering from cardiac Lord, problem. I have annexed the medical certificates.
Now what happened? Now it has been cancelled.
Now they have cancelled it. Lord, I apprised them that I could not pay it for these reasons, along with
What
medical.
can be done?
Lord,
Have you allotted?
No, it has not been allotted.
So can you not consider?
let them
Because
consider
We
on
can
medical-
consider, Lordship, in fact, Lordship, I should candidly admit before your Lordship that on previous occasion, coordinate bench passed an order. Based upon that order, the authority allowed some another to deposit the amount. Lordship, kindly indicate they will consider, but this will not create any precedence insofar as the other, because I know that there are several fence sitters who are waiting for this outcome of this order.
No,
So, Lordship, kindly indicate this will not create any precedence.
my medical certificates are
Mr. Chaudhary,
Maybe some another ground will be taken by them.
page 33 is the order of cancellation and page
yes,
36.
Mr. Chaturvedi, he is right because might be it's a test case. This is a test case.
My medical certificates are peculiar to me. My name is written. They may not have the same medical certificates.
No. That's that is neither here nor there. But this may be a test case. Several others are in the queue.
I am told that
coming and saying similar orders. An order has been passed.
They are in queue in front of my chamber, my lord says.
Nobody knows, Mr. Chaturvedi.
I'm grateful,
They
my
must be
lord.
waiting now.
I'm grateful, my lord.
Where is did you make any application for
Page 36 is my last representation. Page 34 is the first one.
Yes, I
Lordship, may I just place the order passed by the coordinate bench? Lordship, kindly ignore the back pages. It is taken on draft print.
Share copy.
In that matter, the writ petitioner raised certain dispute with regard to demarcation of the plot. But here it is for the. But Lordship, I am referring on the ordering portion, penultimate paragraph, whereby the coordinate bench, honorable coordinate bench of this honorable court directed the authority. Eta copy ache order.
ultimate page.
Lordship, that is at page.
Which paragraph?
Lordship. Paragraph 18. The respondent number 3 authority on receipt of notice shall consider the representatives of the writ petition in accordance with law on the basis of such demarcation report. It was related to demarcation report securing
That is a different thing. There was a dispute with regard to the demarcation. I'm not going into
thereafter,
that here.
there is no question of demarcation, the representation to be considered.
Yes. So I'm directing that you consider it sympathetically considering in the light of this. It's a medical ground. Or if you want,
And in that event,
I can allow it here and now, subject to.
Lordship, we can allow it, but with that condition that it will not create any precedence.
As an exceptional this specific as an exceptional
Exceptional case without creating any precedence.
Mr. Chaturvedi, please give me the facts.
My lord.
Which paragraph?
My lord, he was declared H1. My lord would find that at page 25.
No, please, in the paragraphs, please show me from the paragraph.
Yes. Lord, paragraph Lord 6. Lord, he was declared H1.
He was asked to deposit 2 crore 56 lakhs.
My lord.
50%.
My lord.
By 19th of March.
My lord.
That you could not do.
My lord.
Thereafter, on 2 occasions, reminder was given to him.
The petitioner.
My
lord, for the petitioner.
Yes, Learned Advocate General inform me, my lord, kindly, my lord, short passover. He is coming from, my lord, code number 36, my lord, short passover. I request my learned
You
senior.
start, Advocate General is coming. Yes, yes, what is this matter?
My lord, this is my written submission.
Submission.
Yes, sir. My lord, what happened in this case, my lord? Lands of the leases are in interest of the petitioner, and also some other persons were acquired by the common notification. Thereafter, my lord, notice was served on different sections, such as section 9, section 11, and thereafter award was passed according to section 12(2) of the Land Acquisition Act 1894. My lord, my client, my lord, without going into the reference case, section 18, my lord, filed section 28 application. That application was allowed by the officers of the state, and my lord, I was awarded a quantity of sum. Now, my lord, at last occasion, my lord, my learned friend, that is the requiring authority, raised a question whether section 18 is maintainable or section 29 of the WBIIDC Act is maintainable in order to get award, my lord. In that regard, my lord, my first submissions would be, my lord, your lordships kindly see my written notes of submission, my lord, page নিশ্চয়ই দেবো আমার এটা এ করে রাখিস নি পেজ 19 আরে না এটা তার আগেরটা বলতেছি জাস্ট মিনিট পেজ 16 my lord. Page 16 of my written notes of argument. Annexure A. My lord, Form 9. Thereafter, my lord, special notice to be issued under subsection T4 of section 9 of Act 1, 1894. My lord, it means, my lord, that, my lord, acquisition was made under section 4(1) of the Land Acquisition Act. Next page, my lord, that is page 17, my lord.
17 the notice.
Oh, notice. This is also. My lord, 18, my lord, page 18. Annexure B, my lord. Your lordships kindly see, my lord, proceeding under section 11 of Act 1 of 1894. Thereafter, my lord, your lordship kindly see page 19. Form of notice under section 12(2) of Act 1 of 1894. And, my lord, signature was done by the collector under Act 1 of 1894. Therefore, my lord, from beginning to end, whole process was conducted under the Land Acquisition Act 1894. My lord, therefore, my lord, after being dissatisfied with my lord, as notice under section, that is the award, my lord, reference case is my appropriate remedy. And thereafter, my lord, section 28A. My lord, I filed 28A, that was not being disposed of, my lord. That is why I came before your lordship, my lord. Now, my learned friend that raised the question, section 29 is the appropriate authority. Section 29 of the WBIIDC Act.
Yes.
My lord, your lordships kindly see.
You have a copy of that act?
Yes, my lord.
So do you have a photocopy of that?
Yes, sir.
Photocopy. Yes.
Section 28, my lord.
compensation. Where any land is acquired by the state government under this chapter, the state government shall pay for such acquisition compensation, the amount of which shall be determined in accordance with the provisions of this section. My respectful submissions, this section does not come into picture because my award was passed under section 12(2) of the Land Acquisition Act. Therefore, question of preferring appeal under section 29, it does not arise at all. If compensation was granted under section 28 of the WBIIDC Act, only then remedy is section 29 of this Act. But your lordship kindly see from my land was acquired under the Land Acquisition Act 1894 and award was passed under section 12(2). Therefore, if I being aggrieved, my remedy is section 18 for filing reference case. Your lordship kindly see, with my annexures, with my written submissions, I have annexed the judgment of the Land Acquisition Tribunal, page 10. এখানে একটা কথা ওরা বলেছিল না যে পেতে হবে সেকশন 29
Page
10 of the written notes.
Judgment of the tribunal.
Yes. Yes.
And your lordship kindly see, the ordering portion, just page 14. May I read, that the LM is case number such and such in connection with reference case under section 18 of the Land Acquisition Act, and the same is allowed on contest but without cost. The price of the land acquisition by learned LA collector Howrah be enhanced to some of extent and acquired by the collector Howrah from Ato. The petitioner is also entitled to get 30% solatium on enhancement rate and as per provision of section 23 of the LA Act. Therefore, learned tribunal decided that section 18 is very much applicable, and he awarded my compensation. These are my submission. Nothing. One thing, your lordship.
The learned advocate general is on his way. Please start.
My lord,
Now, 20 page 27 of my writ application, page 26.
My lord, just now,
Just
Learned Advocate General sent a message. Matter is going on, my lord. Refer at my lord. Just now I showing this message, my lord.
This is difficult
My lord.
because at his instance, this
No,
time has
my
been
lord.
fixed. I fixed it at 12 for that.
My lord.
Your lordship kindly see page 26 of my writ.
Both of you must be holding conference with him. Please show me the date of notification under chapter 5 of this act. Oh, no, what is this notification?
Section 27 notification.
Section
27, chapter 5
No. Chapter 5.
of the WBIIDC Act.
When it came into force. Please show me that notification.
No, nothing.
That is not.
But Banerjee, that's the only submission. Then you are gone. Mr. Banerjee, please kindly come to the act. Please see section 1, subsection 3. Please read it loudly. Of the WBI, do you have a copy of the act? Yes. Section 1, subsection 3.
This act, except provisions of chapter 5, shall come into force at once.
Yes.
Provisions of chapter 5 shall come into force on such date as the state government may by notification appoint for this purpose different dates.
Show me the notification when the subsequent chapter 5, section 28 comes within chapter 5. Please show me the notification. End of the matter. Banerjee must be having that information. This is a factual information, not a legal point. Must be ready with facts. The Banerjee, you are arguing, the learned advocate general is arguing. You are saying this provisions, not that provisions. This is the basic thing. I'm also looking this act for the first time. So this is a factual instruction. Then the basic thing, you have raised a point as to the applicability, whether those provisions are applicable at all for that 1-3 notification. Nowadays, I've come across another matter. You are unable to produce the notifications, gazette notifications nowadays. Inland Fisheries Act, section 17A. No. Then, how are you applying these provisions of that statute? You are taking actions.
There's some judgment of our regarding Salt Lake property where same ground will.
That also no notification is there. Here also no notification. Notice the notification. Factual instructions that you should take. It's not for the learned advocate general to take this factual instructions.
Sometime. Fortnight. They have to find out what the notification is. I don't want to come again and pay for another adjournment that they have not found it.
Banerjee, it's very easy to say these provisions will not apply, that will not apply, these provisions and that provisions. After all these proceedings, and this you are taking at the point of payment. Be ready with the amount, I'm telling you. Be ready with the amount because you are getting sufficient notice now. So by sufficient time has also gone by. So be ready with the amount. If it is decided, if it is not, it's a different thing altogether. If it is in favor of the petitioner, then you should not again say, please give us this much of time. It should not run from that date. It should run from this date. Heard the learned advocate for the petitioner. Next matter.
But I appear for the petitioner.
Yes.
But here.
What again? Same matter?
No, no, no.
This is with regard to
Rayati land, but the mineral concern melody is quartz. But I was granted LOI. But kindly sees Lord the
What happened? What is the dispute now?
Yes. Now, my lord, I was granted LOI. Lord, I was not required to undertake certain steps. Lord, with regard to clearances. Lord, like my lord, in respect of the sand mining, Lord, I have to Lord submit Lord the mining plan, the mine closure plan. Then I have to take clearances from the forest department. Then I have to take the clearances of the environmental clearances. Lord, all these Lord are time taking, and Lord, these are interdependent. Now, Lord, this Lord took substantial time. By the time Lord I could Lord obtain all the clearances, Lord, the initial time of LOI had expired. So Lord, I applied
for extension of time.
For extension of time of LOI.
validity of the LOI.
LOI. And Lord, I have not mentioned there, Lord, that this took so much of time, and the last of such Lord happened on this date. And within 3 days, I make an application for extension. Lord, that Lord has been rejected. Lord, kindly Lord comes to page 25. Lord, this is Lord the LOI.
When the time expired?
Lord, the time expired in Lord in March 2024.
March 2024.
2024.
Yes, but my lord, I would show my lord, this last clearance, my lord, that I have received from the forest department for felling the trees, that came on the 6th of May 2025. And on the 8th of May, my lord, I made it.
Where is the cancellation?
My lord, the order of cancellation my lord, is at page 40. At the operative portion is at page 42.
Before concluding,
44, the third paragraph, starting with the words, according to the said order.
Yes.
May I please, Mr.
Yes, according to the said order.
According to the said order dated 24th September 2025 of the Ministry of Mines, where the state government had issued letter of intent by whatever name called for grant of mineral concessions before 20th February 2025. And such letter of intent was valid as on 20th February 2025. Lord, I pause here for a moment, Lord, for the sake of convenience. Lord, mine was not valid because, Lord, the clearances were, Lord, undergoing. So for that reason, it automatically lapsed, not that it was terminated. Or where the auction process for grant of mineral concession has been concluded and preferred bidder has been selected before 20th February 2025, but the letter of intent for grant of mineral concession has not been issued.
So according to them, their decision is that you did not apply for extension
within the validity period.
The validity.
Within the validity period. Now, Lord, kindly sees Lord page 34.
Now, Mr. Chaturvedi, there is a distinction between extension and renewal.
Lord, I come to that. Lord, kindly Lord sees Lord page 34.
They're taking the plea of extension.
Lord, I come to that. Lord, kindly sees page 34. Lord, I'll come to that.
Page
34.
Yes.
Now, Lord, this is Lord essential.
No, Mr. Chaturvedi, I'm not on that. I accept your all submissions.
My lord.
That the essential documents required for this, you could not get prior within the validity period.
And it
Let
was
us take it to that extent.
And it was not to be granted by the state. So the left hand is delaying.
It's not that, it's for your fault.
My lord.
Might be the authorities, those competent authorities took time to process
My
those
lord.
applications to issue certificates.
My lord.
And in the meantime, it's to expire.
My lord.
But the question is, what prevented you from applying for extension prior to that, stating these facts? Because extension and renewal stand on different footing.
Lord,
Mr.
I fully bow down.
What is
Now,
your
my lord,
position on that?
yes. Now, my lord, let us, my lord, see, my lord, what is the policy of the government, my lord, apropos, my lord, these LOIs. My lord, there are, my lord, two, my lord, circulars of the government. My lord, one is 8th of August 2025, when, my lord, the 2021 policy, my lord, was coming into force to facilitate the transition. My lord, all LOIs, my lord, have been extended. All LOIs will not have been extended till 31st of December 2025. My application,
LOIs were extended.
all LOIs have been extended.
On what ground?
But it is said that in view of the transition, the
Transition from
2016 mineral rules were existent
2021
to 2021. Now, these Milord LOIs, which were issued in 2021, 2022, all LOIs, Milord, for this long period, Milord, the delay was condoned. And by a memo,
that.
yes.
You have not annexed that.
No, Milord, this is Milord. ওইটা দেখি তো 8th August এইখানে আছে No, just a minute, sir. Yes, yes,
Today
it is
all
here.
your matters are for condonation. Condonation of delay, section 5.
Lord, kindly see, Lord, the last paragraph. একটাই আছে, আমি আমারটাই দিয়ে দিই। আমি দিয়ে দেবো।
Have you paid that 1/3 of the bid amount?
No, this is not on Rayati land.
Lordship, the notification which my learned senior advisor has placed before your Lordship, this is with regard to sand. This is also quartz, this is also minor mineral. This is on private land. His own land, he applied for grant of license. In 2022, Government of West Bengal issued a notification that is called Rayati policy in partial modification of the 2016 rules. By virtue of this policy, the Rayas who have mineral bearing land, if they have land over 1 hectare, they can apply to the competent authority for grant of prospecting license. So these notification with regard to where the lease would be granted on government vested land. But the thing is, his client applied within the due time, because in all other cases, whenever the application has been made,
According to this extension will not inure to his benefit.
Will not. I say I am
really not, because it is.
I am also saying, I am saying, my lord, I indicate to my lord, I was answering my lord's query, Lord, as to whether there is a policy decision of the government. There is no provision. I said the government has taken a policy decision in respect of their own lands. In respect of their lands, they are extending the LOI. This is in respect of my own land. But the state exchequer is going to benefit.
Can a direction mandamus be issued?
But I have made a representation. I have made a
to frame a policy in a particular manner.
I have not
No, Lordship, there is no policy, but Lordship, I admit that previously, all because in this Rayati policy, several applications has been dealt with by the corporation. And it is admitted position that within a period of 12 months, these clearances cannot be obtained. There are various procedures. So as and when the applications were made by the applicants for grant of validation of the LOI, that has been granted, provided it was submitted within due time. I know that, I admit that the petitioner has invested huge amount for the purpose of, but the thing is, had he applied, he should have
to put it in a different manner.
Lordship.
Let us assume you are also admitting that the validity period is 12 months. It's not possible to comply with all
Yes,
formalities.
that is the admitted position.
Admitted position. Now, you also cannot for sure say how much further time will be taken.
That's why the usually extension is granted.
So now, let us assume that in a particular case, the party, an applicant applies for extension within the time you extend.
Yes.
And there is no default on the part of the petitioner or the applicant in that case also to obtain. there might be a further necessity to extend it.
Again, it will be extended. It is not that it will be granted for one time.
So if that is so, now he has all the valid permissions. Why don't you accept that? Because even assuming that he applied, you extended, there might be an eventuality where within that
In fact,
extended,
within
that
it is granted couple of time also, not that single by another.
that is, if that is possible, now he has all the documents. It's
Now he has to apply for environment clearance. He has obtained mining geological report.
He has all.
I have obtained, but
Forest
when
clearance has
He has
obtained.
admitted he has not obtained.
He has, unless the LOI is revalidated, he cannot apply for environment clearance.
Only the environmental.
Right.
Yes, he
Forest
has
I have.
obtained the forest clearance.
Yes. So only the environmental clearance and how much time it takes.
So see, usually it takes depends upon the, because since he has obtained the forest clearance, because maximum time consumed regarding forest clearance, he has obtained forest clearance, which is a part of the environment clearance. So after obtaining forest clearance, he has obtained.
Condition precedent for obtaining
Yes, yes, yes.
environmental.
If that mineral bearing area falls within forest area, he has to mandatorily obtain this forest clearance.
that has been obtained.
That he has obtained. Now he has to apply for environment clearance, but since his LOI was not valid on the day of making such application, it was not considered. Then he applied for extension of validity. As the application was made after expiry of the validity period, it was not extended.
On February 20th, 2025, this validity has been.
Say to his submission that if it was not within the validity period, can it be extended? What is your submission on point of law?
No, Milord, kindly sees that on 20th February, if my LOI was not valid and existent, I need not had to apply for extension. It would have automatically should extended till 2027. This is another notification. I am only on, Milord, that I have.
Why are you giving it one by one? You should have given your best notification. Yes.
Number kindly sees B.
This is for what? Please give a copy to Mr.
Yes.
The contact?
It 24th
So this
September.
is quartz also.
I have.
This is Milord in respect of quartz. Hence, Milord, I am showing this to my Lord now.
Yes. Now it's which page?
Milord, kindly sees, Milord, the last page, Milord, B. Where the state government had issued, my Lord has very kindly got it, where the state government has issued letter of intent by whatever name called for grant of a mineral concession before 20th February 2025, and such letter of intent was valid as on. But I get stuck up only here. Or where the auction process for grant of mineral has been concluded, preferred bidders had been selected before, but letter of intent for grant of mineral concession has not been issued. The mining lease shall be granted and executed in accordance with the rules made by the state government in respect of minerals within a period of 2 years from date. Lord kindly sees the date 24th September 2025. So this Milord gets automatically extended, Milord, till September 2027. I have made substantial compliances.
Yes, Mr. Shah, what do you say to this?
Lordship, I also gone through this notification, Lordship. I leave it to your Lordship.
I'm grateful.
Thank you.
Now, this policy was introduced to minimize the illegal mining. So, you know, in Bankura, Birbhum district, there are huge illegal mining. So, the persons who have their own land, they were allowed to apply so that they could extract minerals in a scientific manner. That is the purpose for introduction of this policy.
It's a privilege, Milord, to have fair adversaries like Mr. Dev. It's a privilege, Milord. And I don't say it, Milord, in front of him in court, but I say this even outside court to him.
While having a cup of coffee.
Yes, that
I
I
am
think.
to offer.
Yes,
Now
he's
he's
entitled to that.
Yes.
No, but now he is senior to.
Kindly. That is an embarrassment. That's an embarrassment that Mr. Dev could have saved me from. Please.
Yes, Mr. Chaturvedi, where are the facts?
My lord. my lord, kindly Lord, paragraph 5. And then Lord, paragraph 8. LOI was issued.
Paragraph 8.
LOI was issued.
Now it was valid till
Lord, this was
prior to the issuance of LOI, he paid the amount.
yes. The LOI was
Till
Lord 5th of March 2024.
where do I get that?
1 year, 6th of March 2025.
Lord, my lord would
Any document?
Yes, page 25.
page 25.
Yes, yes.
This I can help you.
LOI.
Page 25 is dated, my lord, 6th of March 2023, and it's for a period of 1 year.
Yes.
Next page 26. Serial number 1. This LOI is valid for a period of 12 months from the date of issuance.
Date of issuance. So it expired. So date of issuance is
6th March,
of
5th
So it
March
should be
2024.
5th of March 2024.
24.
That should be the
Yes,
My lord.
date of expiry.
and thereafter you obtain the clearance. Where is the
Page 28.
Page 20
Geological application.
is page 28 is geological approval.
so the last of the approval is of forest.
Forest.
Page 33.
Page 33.
31 and 30.
So that is the last of the clearances
Yes.
which you have
You
obtained. and
obtain
only
a
the
geological report,
environmental
thereafter
clearance
mining
is
plan.
awaiting.
Yes.
The last of the clearance is at page 32, which is at on 6th of May 2025.
32 is from which authority?
Lord, this is my lord again from the
Divisional Forest Officer, Bakura.
Forest.
Yes.
But this my lord, this is another certificate. This is called certificate of developer. It is under form.
This is the last certificate.
Yes.
Yes.
On 6th of
Only
May.
environmental clearance is awaiting.
Yes.
The petitioner claims to be the absolute owner Disposed of, yes.
Item number 2 and 3.
2, I am for the petitioner.
Yes, who will argue first?
My senior, but senior will answer.
I'm not on facts.
These are my petition, my lord. If your lordship takes up my prayers,
Yes.
and look to my lord, prayers C.
57.
Prayer,
C.
you have to proceed from A, B, C.
No,
You cannot directly come to C.
no, that's an independent prayer. Independent prayer.
You don't want me to look to prayer A.
Not for the moment. Set aside and quash the memorandum issued through such and such January 20, 2020.
What is the memorandum?
And it turns to 25.
So to set aside the memorandum,
Yes.
prayer C.
Yes, bro.
ঠিক ফাইল দিলেন, এটা
3
কোন
নম্বরটা
ফাইলটা
দিয়েছে,
দিলেন?
3 নম্বরটা দাও।
অন্য ফাইলটা দিয়েছেন।
Well, we were challenging this memorandum by which the authorities said that all mutations shall stop. And this was not an order, my lord, under the Land Reforms Act. Have a look at page 25. So by this, I'm sorry. So by this administrative order, my lord, the officer was trying to, my lord, curtail a statutory remedy. This could not have been done. This goes back, my lord, even to that judgment of Justice Patel in the Salt Lake matter, by which, my lord, by way of an administrative order, the entire the statute was said to be kept in abeyance. So this is not an order, my lord, under the specified act. So High Court does have jurisdiction.
High Court
does have jurisdiction. This is not, my lord.
Does, or you want to include not thereafter?
No, I'll say has. Because here, my lord, this is not an order or an action under the specified. So the tribunal doesn't have jurisdiction, my lord, to do anything with this. The possible answer could have been, my lord, that this is stopping a provision under the Land Reforms Act. But I am on, my lord, that the person who is, my lord, would probably look at 6D, but 6D doesn't apply here either.
Yes, yes, Mr. Chatterjee.
Your lordship is looking at something. Your lordship looks at.
I'm looking at because we will be arguing on the 1997 Act. So I've opened the 1997 Act for your assistance.
For 6D.
6D.
My lord is probably looking at section 6.
No, I have not started looking at. You can invite me to any of the provisions.
All provisions. Any provision.
6D.
Yes. Looks to 6, totally.
Yes.
That's the jurisdiction, power, and authority of the tribunal. Subject to the other
So according to you, it does not fall within A. It does not fall within B either.
Either. C also.
Not C.
Definitely not D.
Definitely
not D. Why? Applications relating to matters under any provision of a specified act or matters relating to any constitutional validity of any act under the provisions of a special right. So this will not even fall under that. And then, my lord, E, adjudication of matters, proceedings, cases, and appeal which stand transferred from the High Court. The closest which would have come, my lord, is D, And my respectful submission is, my lord, it doesn't fall under D at all.
Closest is
D. And if your lordship looks to D, my lord, applications relating to matters under any provision of a specified act or matters relating to any constitutional validity of any act under the provisions of a specified act.
Now, Mr. Chatterjee, according to you, it is a policy decision. How this notice?
No, my lord, I am saying this is an administrative order, not an order under, my lord, any of the specified act.
Administrative order formulating how this section 50. That's
my respectfully, sir, I
last
should have never
paragraph.
said no.
Please kindly come to last paragraph or the first paragraph of page 25.
Yes, my lord.
To
In order to streamline the process of mutation
and conversion.
My lord.
So certain guidelines, how this
This is not under the Land Reforms Act.
To streamline the process of mutation and conversion. Mutation and conversion is last paragraph, section 50 of the 1955 Act. So according to you, this is not directly matters. It formulates some policy or certain guidelines as to how these matters are to
Shall be done. So this is not something which is done under the specified act. I am saying, my lord, he has no authority at all.
Now, Mr. Chatterjee, if the virus of a statute, accepting the statute by virtue of which this tribunal was constituted, the tribunal is empowered to.
I am not challenging the statute.
You are not challenging those statutes. If that is the extent of the power of the tribunal, can it not go into this?
My lord, if any act which was done under the specified act, the tribunal can. There is no dispute on that. But if this is an act, yes, matters. But the tribunal doesn't have jurisdiction over, my lord, an authority exercising administrative powers. He is regulating, my lord, something which is to be done. Where does he derive this power from? Not from the Land Reforms Act. Not from any specified act. He doesn't have any power. And that is where, my lord, I am challenging this notification before your lordship. Saying that he doesn't have any power to issue such direction, saying that no mutation can be done except this. See, my lord, the fourth paragraph. I am on that, but I am saying, at the sake of repetition as well, that if somebody doesn't, a land reforms department does something which is not related to a specified act, is not covered by the Act of 1997. My respectful submission, lordship kindly, my lord, considers it. If he was exercising jurisdiction relating to something, my lord, under the Land Reforms Act, I would have understood. This is not
or any of the specified acts. Here it's Land Reforms Act.
Yes. My lord, I have tried to check up whether this falls within any of the provisions of the specified act. Subject to correction, my lord, I have not found that. If what he has done, saying that a particular section will remain otious, apart from a few things, that is not something which a right he derives from the act itself. Land Reforms Act,
50-51.
Yeah.
Why he does not have the power?
No, I have not seen, my lord, an enabling provision here. I must have mistaken or, my lord, I could have, but I haven't seen, my lord, a provision which enables him to do this. To keep a provision, my lord, at bay is not something, my lord.
Where is the earlier memorandum? Because this was
That my
the
learned friend.
modification of
Yes.
the earlier memorandum.
Yes.
Where is that?
Earlier, my lord, was that entire mutation is off. This was, my lord, where they gave an exception that these are the places where it can be done. The others can be done, but for this it cannot be done. This was, I'm subject to correction, my learned friend.
No, I do not have. Taking.
সেটা আমি তোকে বলছি, সেটাই আমি বলছি।
No, I did not. No. I did not check that previous notification.
Because why this memorandum was issued?
This memorandum is modification of the earlier.
Correct.
For that, my lord, we need to see this.
13th of
2017.
Stop.
No, I don't know. My lord, I don't know.
After careful consideration is pleased hereby to direct with immediate that the stoppage of processing of mutation of land record and processing of conversion are withdrawn.
জজ সাহেব ওটাই
So
করছে।
earlier there was a stoppage.
That's the 17 one.
Yes, that is withdrawn accepting this. So initially it privacy appears from
Yes.
that paragraph.
Yes.
It was a total stoppage. Now that has been modified, says that stoppage will be with regard to these two categories.
Bhangor, my lord, they had a lot of problems there.
No, this might be not a bit. What's the basis of this? If it's
Absolutely.
pursuant
That
to
is
some,
for my learned friend to say.
some pursuant to some orders, it's a different thing altogether.
Doesn't say so.
No, might be Mr. Chatterjee must be in that.
In the earlier one.
In the earlier
Very
one.
well.
So
My
this
learned
is
friend will tell your lordship.
being modified subsequently by
My
that.
learned friend can tell your lordship that. My learned friend can tell your lordship that. So the other submission earlier, my lord, thanks to my learned friend, my lord, this is what really, my lord, we were after. This notification, if this notification stayed, then even if I went to, my lord, the tribunal, my mutation wouldn't have happened.
And according to you, the tribunal lacks jurisdiction to decide that.
No, the tribunal can only
Decide
say
this. No,
whether
so
the
this-
virus of this administrative
memorandum.
order.
Yes, this memorandum.
The tribunal cannot, because this is not an order under the specified. my lord, I might have missed something, but what I feel, my lord, this is, and I'm ready, my lord, for correction. But this is what I feel.
Dhar, what do you say to this?
My lord, kindly come to section 60
Section?
of the West Bengal Land Reforms Act.
16.
60.
Oh, 60.
Power to make rules. The state government may, after previous publication, time to time, the Land Reforms Commissioner has issued several guidelines.
Carrying out the purposes of this act.
Yes.
Saying.
No, rules by virtue of that, rules are, this is not the rules.
কি বলছে?
Even regulations.
Regulation.
1993 manual is also under this act. Rules, regulations, and all notifications.
62.
62.
62 is to give directions.
Malar.
Not inconsistent with the provisions of this act.
Yes.
To any
So-
collector, revenue officer, pressure authority, as may appear
That's-
state government to be
Mr.
necessary
Chatterjee, so
for carrying out the purposes.
that's a different thing. So carrying out, this is also carrying out the purposes.
Milord, this is stopping the purpose.
That's a different thing.
They have a right to, Milord, for the sake of carrying out mutation.
According to them, this carrying out, not carrying out.
Oh, this is stopping. They cannot stop.
That's
Milord,
the
what
challenge.
happens is, this is carried.
That is on merit.
Authority is there.
Authority
Authority
to, Milord,
this falls within 62.
no, Milord, my respectful submission, it doesn't. Because 62, Milord, is something in furtherance of the act. Not to, like
Chatterjee.
what? Like, Milord, today a revenue
Chatterjee,
officer.
This framing of rules in all statutes.
This is not a rule.
No.
Guidelines
All
also.
statutes.
This is not a guideline either.
So you will be finding that power to frame rules, regulations, and
Yes,
such and such.
yes,
So in the rules, you will find that not inconsistent with the statute act.
absolutely,
In the regulations, you will be finding not inconsistent with the act and the rules.
my lord.
So these are the tires of those.
My lord. So now what
So
happens is,
now here is, that is why it states that it has the power to give directions, not
furtherance.
yes, not inconsistent
So
with that.
moment he stops it, it's not not an action under the act. Because the action under the act would have been regulating, saying that this person will not hear it, the other person will hear it.
So according to you, if certain directions are passed, which according to you is inconsistent,
is not an action
that
under
is
the act.
Article 226, and if it is, that direction is in furtherance before
Of the act,
tribunal.
then it has to go before the tribunal.
Difficult, Mr. Chairman.
My lord, once it is,
Because
it is a provision, no, my lord, respectfully submitting. If it is something within the
I
act,
can decide this point on,
Lordship decides it. Definitely
I
decides
can
it.
give you here, both of you on this. I can decide this.
Decides it because there they will, it will be a ping pong ball, because there they will say that the tribunal doesn't have jurisdiction.
Cannot say so.
They will say.
So.
I'm saying
Cannot.
so.
Because
My lord
this
decides
is,
it. Decides it. I don't have a problem. My lord decides it.
This will only delay your application.
My lord, I have to wait for 7 years before the tribunal. Might as well wait for 7 days before your lordship.
And if you can go there, get an unfavorable order, says no, I do not have jurisdiction, you can right away come to the division bench. And secondly,
That will come after 7 years.
no, that's not after
No,
7
it's
years.
true. Your lordship may not believe me, but it's true. I can show your lordship. I filed a oh mathanere oi gondogole pore. I'll tell you in a matter he was with me, my lord. There were about 100 petitions before the tribunal. 6 মাস He's in a
Also, you are making same allegations in this court. Matters are pending for so long years.
allegations, not allegations. We are fretting even with this order of
Not
sir,
an allegation. That's your. You are
fretting.
disturbed by those.
The
facts.
entire civil code
Not-
has stopped. Has stopped. For 15 days, the civil code and the criminal courts have stopped. And we are clapping hands on that. When the Supreme Court decided, they never thought of this consequence. But again, that is below constitutional, my right to vote, that is most important. But today, my lord, somebody comes into my property, starts building, I will not get a judge to get an order of injunction. People say judge in charge. There is no judge in charge also. Lordship goes to the Alipur court, there is nothing.
Once CGM is taking the duty of all magistrates to
So it's not about, my lord, allegations. This is fretting. We don't realize where we are going. Vote is so important that we forget that the judiciary needs to function as well. But I'm pretty sure, my lord, this your lordship will not find a judgment on this. I'm pretty sure. We'll try and find out.
You are responsible for many matters putting the court into trouble in this time.
62, of course, not him, but
After making arguments, you will be saying there is no single judgment on this.
lordship will
The other
find
matter
out.
also.
Your lordship will
Arbitration and
interpret.
Conciliation Act also you said that.
My lord will interpret it.
Arbitration and Conciliation Act also you said that.
But that was the first judgment which came out. That was the first judgment which came out. It saved a lot of, nowadays, a lot of revisions are being filed from arbitration proceedings.
Mr.
to obtain leave. This matter could be listed top at tomorrow. my lord.
15.
Yes.
Right.
Lordship, 16th, Lordship, tomorrow is the date of election, Lordship.
All right. Let me see. Yes. But I thought that so I have not gone into the correctness of the that revision.
Leaving that open for
No, I have not gone into the correctness. I have not said that's
that's
correct.
fine. That probably
subject-
saves me.
So
That
yes,
probably saves me.
yes, because I have not said. I've said I'm reading the previous paragraph also for your. That apart, the 1947 Act provides for revision of the existing rent of the premises in the manner as laid down under subsection 3 and 4 of section 14A of the 1947 Act as the compensation during the period of requisition. Argument was, I must appreciate, it was thing whether arbitration at what stage was an interesting point after all.
Absolutely. I'm so grateful.
So that's why it took time to deliver. Otherwise,
That's fine enough. I'm grateful.
thank you.
14.
14.
2 PM আছে তো? 2 PM আছে।
14. There are two motions after that.
Oh.
Yes, you are not in 14.
Yes,
You are in which item?
At 2 p.m. 37.
No, 14. Please, there are two motions after that. Yes, where is item number 14? You are appearing. 14, who is appearing?
I am for the statement.
Not today, Koreography. Yes.
15, my lord, I'm led by Mr. Kushal Chatterjee. He is appearing virtually, my lord. Lord, he has undergone an angioplasty on last Monday. Thereafter, my lord, he is not appearing in the second.
Why is appearing?
My lord, there's some urgency in that matter. That is why, my lord. If my lord kindly takes it up tomorrow, my lord, at 10:30 or maybe at 11, my lord, subject to your lordship's convenience.
Why?
My lord, there is a demolition order, my lord, which
I can take it up now. I'm
my lord, I know, but my lord, I'm led by Mr. Chatterjee, my lord, and without any.
Chatterjee is not available.
No, my lord. Perhaps yes. Kindly takes it up tomorrow, my lord.
All right, কালকে রেখে দিন।
Item number 16, sir, for the petition. Lordship, as per your lordship direction, I have served the notice to the
For the state. For the state.
learned government leader as well as lordship the
as well
Cooperative
as
Election Commission and the concerned
No,
cooperative
have you
society.
notified them because indication is otherwise from 2 p.m.
Mr.
I will
Nayak
take up other
learned-
matters.
Mr. Nayak, learned advocate for
Have
the.
you informed him that I will be
Yes,
taking
yes,
up
yes,
this
yes. Mr.
at 2
Nayak,
p.m.
I have informed lordship, he was till 1:40 lordship, till
Have you
rising.
informed him that I will be taken because
Yes, yes,
indication in the list is otherwise. That is what I am asking you.
Yes, yes, I talked to him. He was here till your lordship's rising. I requested that the matter will be taken up at 2 p.m.
You have told him?
Yes.
All right. Can you ask your junior to inform Mr. Nayak? Do you have your phone number? Or? Yes.
Lordship, the matter is, Lord, the petitioner is a treasurer of head of the self-help group. Now, Lordship, the petitioner participated in the election process. Now, filed their nomination paper. Lordship, kindly come to the election schedule.
So, cancellation of a nomination paper, it's an election dispute.
Now, Lordship, kindly, there is.
It's not an election dispute.
No, Lordship, the election, so far the election dispute is concerned, I have not, Lordship, allowed to, Lordship, contest the election.
It's not an election dispute.
No, Lordship, as per the Cooperative Societies Act.
Not. Please show me.
Lordship, kindly come to the regulation, cooperative regulation.
Do you have a আচ্ছা আমাদের cooperative regulation টা আছে cooperative society
My lord, I appear for respondent number 3, 12 and 13, my lord.
Yes, Mr. Nayak, what do you say?
My lord, tomorrow is election. Tomorrow is election. Law says, my lord, if default, it's a case of it's a matter.
Rejection of nomination.
Rejection of nomination very rightly done because there are a lot of, my lord, female self-help groups, and from every group, one representative.
But is it not an election dispute?
Yes, election is this is a purely election
Yes,
dispute.
my
Which
lord.
can be referred to, my lord, the regulation 35(1). That's the only remedy.
Regulation, please show me that regulation. I was searching for that. Regulation?
Regulation 2012.
Yes, 2012. Which regulation says this?
35(1), my lord, 3, 35(1).
35(1).
3, subsection 35(1). Lordship, last.
5, yes. Any dispute relating to election of disputes
yes.
shall be referred to the within 30 days from the date of arising of such dispute.
Right.
Now, Lordship, kindly see when my nomination has been cancelled. Kindly come to page 89.
Sir, all these relates to
Lordship.
election dispute.
Lordship, kindly see that 12th February, my nomination has been cancelled. Now, Lordship, 13th, I have received the certificate from the concerned bank that I am not a defaulter. Lordship, when the date of
that
election, there
cannot
is
be
no
stalled.
13th.
Sir, for that election cannot be stalled. You can raise a dispute. If you succeed there, election will be cancelled.
Lordship.
That's the procedure.
Lordship, that's the procedure, Lordship.
This procedure body has been constituted for everywhere in all elections, not only in these cooperative societies elections. So there's a provision for deciding this election disputes. So that is, and you have to go there, and 226 is also not maintainable after initiation of the process of election.
Lordship, kindly come. Who has conducting the election?
Where are those line of decisions? Have you brought those, consulted those? Once the election process starts, it cannot be stalled.
And
All
moreover,
the
if
disputes
the
are to be
election
decided.
is hold, Lordship, kindly
Nothing will
enter.
happen. Election dispute, if you succeed, this will be cancelled.
Yes.
Lordship,
That's
kindly
the
come. Who
procedure
is
everywhere.
conducting? Lordship, the initiation of the election is illegal. Let's kindly see who is conducting the election. That is the.
Sir, that you cannot challenge. You have
Inspector-
participated. You have participated in that election. You have filed your nomination. You cannot now turn around and challenge that.
Lordship, the assistant returning officer,
So
he
you
has no
waited for
authority.
this time. Yes, if it is so, raise all points in the election dispute.
My lord.
Lordship, let me
There are
participate in the election.
How can it? No.
Lordship, kindly consider
That
because
means allowing your writ petition. What remains if I
no,
participate?
that will be abide by this result of the election dispute. Because kindly see, Lordship, the petitioner is a bona fide and filed.
Please show me an authority which says after commencement of election, 226 is maintainable to stall that. Please show me that. Please show me a decision on
So
that.
this is palpably wrong because kindly.
Sir, please, do you have any authority? There are authorities galore against you. Have you consulted those decisions?
So tomorrow is the election, Lordship.
You should have been prepared with this.
And moreover, to participate in election, my lord, lot of processes are
There
being
are
followed. They have not
line of
completed.
decisions.
Lordship.
I am a part of the division being judgment of.
Lordship. Lordship.
I can permit you to raise this as an election dispute.
My lord.
Tomorrow is the election. You raise a dispute. If you succeed,
My
this
lord.
election will be cancelled.
Lordship, kindly record that the initiation of the election is absolutely illegal.
Why did you participate that? Why would
Lordship,
not
kindly
challenge
come
at that
page
point of time?
88. Inspector of Cooperative Society
Why
has
you did
no
not-
authority.
Why you did not participate? Why you file your nomination then? Why you did not challenge at that point of time? When the election notification was issued?
Lordship, the election notification issued.
When the final voters list was published?
কোন রেজলিউশন বলছে আইনের বাইরে বলছে নাকি ইলেকশন কমিশন বলছে এনি অফিসার দেরফর অপারেটিং
21st January 2026.
So what were you doing for so long? Should have come then and they are saying that yes, this is fully set aside. It does not have any authority to issue this.
And withdrawal of nominations were fixed on the 13th.
So you participated
And that year
and
participated
you have
also.
approached only after it was cancelled, your nomination.
Within 12 scrutiny.
He is a defaulter member, your lordship.
No, he says that
That too later on.
No, no, later on,
My lord, when
not before the time of submission of nomination, not thereafter.
Yes, yes, kindly see,
Kindly
kindly
see.
page
Where is
number
that?
71.
Page.
Page 73.
But Mr. Mukherjee, if I go into the merits, then I will not allow you to go before the election.
No, no, Lordship, so far they are saying the defaulter.
If I go into the merits, Mr. Mukherjee, I will not allow you to raise
I am
that as
going
an
to the
election.
merit, but
No,
Lordship,
Sita
my learned friend and
My
showing
lord,
that I am
that
a
it means
defaulter.
He's a defaulter.
all the points, my lord, are covered under this election dispute, number one. And number two, my lord, scrutiny of all the nomination came to an end, my lord, on 11th.
13.
11th, 13th was date for withdrawal and declaration.
The 13th.
So by 12th, my lord, he could not produce. By 12th was a date for scrutiny and everything.
Yes,
By after
13th
fourth-
February.
The order of cancellation.
There is no order. No, this is also
order, my lord.
no order of cancellation has been
His
issued.
name was not
As per
figured
the
in the voter list because when the objections were put in and all were considered, all were called for my lord hearing,
Them produce the
my lord,
records
they
because-
failed to substantiate that she is not defaulter. She is not defaulter. She was figured as defaulter member, the society. They are a self-help group. Therefore, nobody was elected. Similar, under similar circumstances, two other groups have been deprived of. Two other self-help group they have been deprived of. She is coming in another group. So three groups have been deprived of. And in 13th
only
list,
to make
in
the
13th list,
one
three
group
persons have been no,
uncontested. Lordship, this is the purpose. Only one group to make uncontested.
no. He doesn't.
Lordship, you raise that.
Lordship,
Why
kindly
not?
cease.
Not why it's a matter of group. It's a 18, my lord, 18 groups. 18 members will be coming up.
So I have annexed the entire Lordship the bank statement and Lordship the
Yes, what
kindly
is this?
Sumati Sarnivar Dol. Your Lordship kindly sees the second last name. Sumati Sarnivar
Yes.
defaulter.
Yes.
Yes.
Yes,
And
now
kindly sees this is the letter of 11th
11th
of
of February 2026.
Yes.
2026.
kindly come
So
page
at the
98. Kindly come page 98.
Allow him to make his submission. Yes.
the last date for filing of nomination was 11th. Scrutiny was on 12th. After all persons filed their nomination on 11th, this letter has come from the bank. So on the date of scrutiny, it was categorically admitted by the bank that he is or she, this society is a defaulter. So in this case, a person who himself is or herself is a defaulter, your lordship, they come to the board. What will be the effect on other cooperative societies?
And what is the where is the document?
Page 98.
98.
This is the bank certificate.
That is on 13th of February 2026.
Your lordship.
Yes,
So grateful.
this defaulter has been recognized illegally. That is by the concerned bank. Bank is a party. I have not taken any loan. Bank has wrongly, Lordship, put an entry as a defaulter.
All right, you raise
Lordship,
that
this,
as an
that's why
election
page
dispute.
90.
And my lord,
On the next
I
day,
allow you to raise this point as an election dispute. The petitioner.
The authority
Made all points. Raised all points for the appropriate.
let the election disposed of within a certain period.
You have not filed yet.
Nobody
Nobody
in
knows.
course of tomorrow I will file.
Nobody knows how many election disputes will be filed.
Also, kindly, so 1 month.
If it is not disposed of, you first file, then come, I will consider. Yes, call the next matter.
Lord, one humble submission, my lord, with regards to item number 15. My lord, can it be with the first matter under the new motion tomorrow, my lord? This is the only request because Mr. Chatterjee will have a checkup at 1 p.m.
Who is your other side?
My lord, I shall inform my learned friend, my lord. There is no difficulty in that, my lord.
Why are you giving trouble to Mr. Chatterjee?
No, my lord, he wants to do the matter. That's why. Insisting, my lord. Can it be the first matter under heading to a new motion, my lord, tomorrow?
After all, his decision. 14 টা
15
টা কালকে একটু উপরে করে কি করে
Acha,
What is the urgency? It is to
the demolition of a structure in a converse land, my lord. The land has been converted.
The demolition will take place.
And they have deposited the police cost today itself. Maybe within 2 or 3 days, my lord, it will be taken away. Acha.
Item number 37.
When at last occasion, my lord was pleased to hear this matter. My lord had directed the concerned municipality to come back with the report, and date was fixed. Matter was to appear on 12th February.
Yes, where is the report, Mr. Banerjee?
No, report we have already asked for, but yet not received the same.
Then I am injuncting you.
But they have no locus standi.
That, you ought to have come.
Lordship, kindly have a look. I've already sent for.
The
Who
last
to
occasion,
injunct?
this instruction was
No, this is
without giving us copy. On the last day, Mr. Banerjee said, I will supply. Till date, he has not supplied. What is that?
We have asked for the physical verification to be made to the BLLRO, which has not been made. Maybe they are a bit stuck up with the SIR and other things. I'm not on to that. We have already sent forward.
Kindly see the speed they are doing the construction.
They have already
see the speed. On the other hand,
already said we have.
Kindly see the last supplementary affidavit I had filed. Kindly see.
My lord, একটু দেন না
Supplementary.
I had intimated the local PS officer in charge.
Yes, Mr. Dev, what is the instruction?
My lord, instruction, my lord, I have written all the things, my lord. That is the application for plain paper, plain fortification, that is not comprise CS plot number ato visible and ato ultaranga before the undersign. Now, with the passage of time in subsequent survey settlement operation on reconciliation of finally published map and the respective revenue records, the CS plot in question is found to be subdivided in more than one RS plot and several LR plots, my lord. That I have given the entire thing, my lord. My learned friend should go through that, man. Otherwise,
Yes, I will go through. In the meantime, kindly injunct.
Mr. Dhor.
Yes.
Neither your predecessor's name nor your name has been recorded in.
I knew that was the submission would be coming, because last day that was the submission of Mr. Banerjee. I have the land records in my name. I wanted to see that what kind of a submission they would come up.
Don't raise your voice. At times you appear on that. Your voice so much. You also might face that in some other manner.
Kindly, my lord, appreciate, my lord.
So don't raise your voice to Mr. Dev.
We have not yet. I have not yet came up with a stand. I have just indicated that this is the situation.
My lord, kindly protect my property only. All I am trying to say, let the affidavits come.
In fact, the report in fact says the concerned plots also be possessed of different persons.
It's a vacant land. and they are going ahead with, kindly see my supplemented affidavit once. Safe drive, save life. All buildings are coming up. All the cemented construction is coming up. Boundary wall, the grill, everything, and municipality is saying no, we are not doing it. Well, let that come up with the backed up with the affidavits.
Mr. Dhar, your client is very powerful. I'm asking you. Is the client very powerful?
Well, may I? Well, I have just one copy. Well,
My lord, please ask him to give me that copy.
sir, একটাই copy him.
কেউই পাইনি।
This is just.
Not getting.
No, I did not.
You have to turn over so many pages, you will not get it. I've seen only one page. I've got an idea from that.
Not vested in this position is in possession of different person. So Lucas and deleting the same from the above question on the side record is corrected accordingly. Oh. Well, my lord is referring that taking photographs.
They want to know how powerful your client is.
Well, kindly mention my lord, what is.
It is the speed at which the government officials are working. Then I should take. I must fix a shorter time for compliance. This is the speed at which the government officials are acting. Now, please look at it.
21st December 24. He is doing this. This is coming under the same.
Notice also served by NIC. 5 days.
No.
5 days.
That's everywhere. All the mutation cases, my lord, will find this type of format.
When have you applied? Please show me the applications.
It is there. Then.
And show me the Mr. Dey, please produce the records for serving notice.
Yes.
I must see. Then I now think the shorter time is to be given because you are acting at a very
this application is
electronic speed, I must say.
Yes. 1, 2, 3. Third page is the application.
Application file, 5 days, mutation done, notice served. Very good. It's appreciable.
Kindly call for the records. Mr. They can bring it.
21st December, application filed. 24th,
now
notice issued.
Through a software, NIC. NIC has
also issued.
No.
NIC.
Yes, notices generates through that app, but service has
yes, 5 days notice served. So for demarcation, I think notices also shorter time, 1 or 2 days notice, demarcation within 3 or 4 days. Mr. Dey, please, this has to be done. This is your authority. Please see, look at this.
Only for that reason, my lord, I break.
Please see. Now please pay for
বাঁদিকের
shorter
ডেটটা
time for
দেখুন,
this demarcation and service of
এইটা ডেট
notice.
24/31
18 সাল
18 সাল।
Very powerful, Mr. Kaur.
18 সাল বলছে 25
All the deeds in respect of this
My
property.
lord, please give me a copy.
Yes, yes.
Totally, my lord, if your lordship will come to my report.
This supply of
Yes.
Mr.
My lord, according to
I'm
the-
keeping it in the next week.
Yes, my lord.
Mr.
Madam, for a
Mr.
second.
Dey, please give a copy to Mr. Dor.
Oh, I have already handed over the
You have
same,
got
my
this
lord.
Yes.
copy?
Right now, I have.
The report of the Yes, take it back.
It will be used in the,
Short municipal
হ্যাঁ
letter.
ওই ওপরে আছে,
Yes.
ওপরে আছে।
Monthly list. Item number 556.
My lord, this is my contempt application.
Yes.
My lord, this is my contempt application, my lord.
First time.
No, my lord.
My lord,
My lord,
your
several
lordship, my
times
lord, appointed me, my lord. I requested
my
the
lord, 88 years old lady has
the
getting
PDO,
his
my lord,
family
to
pension.
complete the same, my lord.
2024, my
But
lord.
my lord, as the all the records was not, my lord. For that is, my lord, I request him to give all the records.
My lord, I have
And my
already
lord,
been
he-
given in 5th February 2023. My lord, first of all,
2026. Yes, Mr. Dev, have
My
you
lord,
got those
give me-
documents?
My lord, my lord, up till now, my lord, I am not getting those documents, my lord.
Give it to him. Please give
My
it
lord,
to
yesterday,
Mr.
my lord, I
Today,
request,
just
my
now
lord,
I
I
am
request
giving.
yesterday to give me the copy, then I can.
You have given him, it could have been expedited.
And my lord, give.
My lord, today, just now I am giving, my lord.
Alright,
My lord,
please
my
give
lord.
it to him. Mr. Dev, how much time you want?
1 month, my lord. But that is after 9th, my lord.
After 9th of March.
March. That is the process is, my lord, after video is now.
Maybe because you also need some
He's
time
a
to go
video,
through.
my lord. So, my lord, he is very busy now. Only for that
Tell
reason, my
me
lord.
at what time.
Then,
Next,
my lord, monthly list of April. এই আমি তোমাকে আমাকে দিও আজকে না হলে হবে না
cannot be done because they also has to be given some time. Because they are otherwise.
Since 2024, my lord,
I appreciate that.
My lord, video is not working seriously, my lord. He's
Unless that
bypassing
is
the
verified that they cannot release that. Please understand that difficulty also. Mr. Dale, on additional government leader.
I am for the petition.
take back.
Yes, yes, you take back your copy.
Yeah, আজকে দিয়েছি
Copy টা দিয়ে দিন। Yes.
I am for the petition.
First time.
First. My lord, the aim of the contemptor number 1, my lord, leave may be granted to add the new person who has.
New incumbent. The learned advocate.
One. The others are there.
Contender number 1.
One.
Which post?
Commissioner of School Education.
On the prayer of the learned. Yes. Yes.
On 28th November 2024, there was a rejection by the lordship for direct purchase within 4 months.
Yes, Mr. Dev, what happened?
Now, my lord,
My lord,
the matter came up for
my lord, in this matter, my lord, the respective officer, my lord, is in law, is on leave, my lord. Only for that is, my lord, he could not come to me, my lord. My lord, the day before yesterday, I
Leave for what?
leave for physical, or only for that is, my lord, I pray. Otherwise, your lordship can issue rule. I have no other alternative, my lord.
When? How long? How much time you want?
I pray for only 7 days, my lord. If he comes, my lord, he will give me the instruction. What is the position now? Whether he money is, if he joined on the,
No person is in charge now.
my lord, he will, he is in charge of all the.
Mr. Pan, the difficulties in these offices now
May I
is
say one thing? 28th November 2024. Then, my lord, last order, your lordship kindly see 27th November 2025.
Give me one
Now
chance,
this
my lord. After
situation
that, your
arises
lordship
today.
issue rule.
Kindly see.
on the prayer of the on the prayer. Yes.
I'm the petitioner. In a civil divisional application, your lordship directed the opposite party to carry out the repairs as per his undertaking within 1 month.
Division.
Revision. Anything out of a revision. 3rd March, your lordship passed the order, 3rd March 2025, page 24.
Carry out.
The repairing work in terms of the undertaking filed by them or submitted by them.
Yes.
And not with the direction your lordship disposed of, saying that within 1 month it is to be carried out. That period has expired, they have not done.
Repairing. Who are you?
I am not the tenant. My suit was for
The landlord was directed to carry out.
Under section 35 trial court directed. They said, your lordship in that regard, they undertook that they will carry out the repairs within 1 month. Your lordship directed that to be carried out within 1 month. So that is the nature
Mr.
of the direction.
Banerjee, instead of going to that, what will happen? I can give you leave. You can apply for effecting repairs on your own, and other things I am not saying.
That prayer was made. Trial court allowed that prayer. Against that they came in revision. The order of the trial court is already there directing repairing. They did
By
not,
you?
No, by me, my application.
Yes.
They challenged that before your lordship. In the revision, your lordship will not affirm the order, and they undertook that they will carry out the repairing within 1 month. Your lordship recorded the undertaking and directed them to do it within 1 month. So I've already exhausted my remedy and Lord, I came.
Petitioner is directed to serve a copy of this
appear for the petitioner, my lord.
Yes.
The contempt arises of a civil revision, my lord, wherein my lord.
Civil revision contempt, why?
Why? The issue was why my lord kindly reconsiders. Ad interim injunction obtained, we appeal into appeal court vacated. Thereafter, it came up before your lordship. My lord, after seeing the document, restrained the plaintiff from carrying out the construction work. In spite of such order of injunction, my lord.
Order 39 rule 2 is there.
Kindly, my lord. It will
Violation, order 39 rule 2.
Let it be before your lordship, my lord.
Order 39 rule 2, there is a decision.
It's a
Cannot be done.
it's a specific violation of your lordship's order, my lord.
That was the argument we lost. That was our stand. We lost. Bring that decision. Decision.
I shall let it be.
Because that was considered.
All steps taken, 151 application taken in spite of.
Dr. Bhattacharya is sitting in courtroom number 8.
Meantime, kindly direct them to serve, my lord. In spite of specific application in the court bill also.
Two brothers.
Here the
One of them was a professor of a university in the northeast. Other than UQA or contempt, it has been held no. Because there is a specific provision in the code.
I shall, my lord.
That was in violation of an order passed in the civil division application. So all facts civil. I know the surname, not the exact name, some Chakraborty. This is the surname. The others are reported.
Well, I shall bring. Let me kindly direct to serve, my meantime, my lord. Kindly direct them to master.
It's not maintainable by service.
Kindly, my lord. In the meantime, the entire construction of the cooperative property has been changed, my lord. That's the issue, my lord. We have moved from pillar to post. Everywhere.
You have not searched out this, only I have come. Contempt. That also will apply in Mr. Banerjee's case as well.
Different undertaking and directed to carry out the.
Petitioner is directed to serve a copy of this.
Of the first step. Time for the first step.
362.
Yeah, no, 561.
562. Yes.
Time for the first step.
First time. 561, 562 service order, monthly of April. Yes, next.
This is an application for restoration of contempt application.
Restoration of contempt.
Paragraph 2, 3, and 4, and 5.
Yes, Mr. Bhattacharya, why have you violated the order?
No, we have complied with it.
You have complied.
No.
Where is the compliance report?
The compliance report is also in the file.
What was the order? What was the direction? What was the direction?
Taken after a long time.
You are not opposing the restoration application. Yes. Please kindly come to the merit. What was the order?
Order was passed by the Honorable Justice Devashish Kaur on 3rd December 2008.
3rd December
2008. Kindly come to order.
21 is the order. And the penultimate portion of the order, page 25.
দেখো তো অর্ডারটা বার করুন তো 8 ডিসেম্বর
Exception to the report of the complaint.
Where is the direction? Please let me go to the direction.
দেবো আমি বাদ করে দেবো
1st December. The order of
What was the direction? What you were directed to do?
Material law.
Mala,
Therefore-
please to quash the
Therefore, in view of the aforesaid settled principles of law, the charge sheet under challenge, which was issued by the respondent number 4 under memo number such and such, page number such and such to the writ petition is quashed and set aside. Therefore, inquiry report dated such and such, order of punishment dated
Since
such
the
and such,
charge sheet is set aside, all subsequent things set aside.
consequent passed in the auto petitioner are quashed or set aside.
Yes, then
But thereafter no such no directions. Only quashed and set aside.
That means my previous status was left out. And against that order, my lord, they prepared an appeal. Appeal was also dismissed.
No dispute, madam.
Now, my lord,
now what is your grievance now?
because this is this, my lord, I am entitled to get my pensionary benefit. My lord, when
Yes, Mr. Bhattacharya.
Madam,
How can you be told that?
Complied or
Paid.
yes.
my lord, I am
Madam, there are two compliance reports.
my lord, they have given effect.
Compliance report টা দিন
My
compliance report তো ওখানে আছে দেখুন ফাইলে
এটা মানে
yes, where is the compliance report?
subject to correction.
By the container number 2.
Yes, sir.
So what is the container number 2?
Yes, yes.
Yes. Photocopy of the order dated 10th of June 2024. Yes, you have not received this amount. 10th of June 2024, that was released.
My lord, they have paid the my lord, pension when by the improved order of compulsory retirement was passed. From that date, they are.
If you are aggrieved by that, you will be free to challenge that.
Question
Please
is
challenge that, Ashun. The the affidavit, the exceptions to the report of compliance is taken on record. So Mr. Bhattacharya, learned advocate, appealing for the alleged contemner, seeks time to take instructions and revert back on the next occasion, month list of April. Same.
My lord, restoration application.
For restoration to allow.
Restored.
Restoration to allow. Yes, restoration application can after hearing the learned. The next matter. Yes. Who is appearing? Who is appearing for the petitioner? None appears for the petitioner.
Lordship, I am appearing with the petitioner, Lordship.
Yes.
Last occasion, Lordship, rule was issued. But whether alleged contemner was complied or not, I have no knowledge, Lordship. Thereafter, that was not listed. Yes, one learned advocate appeared. It was on a particular date. Rojyoti Ghosh. Please see this. I'm making it not today. Please serve me one notice because the advocate has appeared. Not today. Next. Item number 566. None appears for the petition at the time of calling. My condition has been sought for either. Next matter. Item number 567.
For the municipal lordship, led by Mr. Raghunath Chakraborty.
You are for the
Municipality lordship, Moyastora municipality, led by
Contemner.
Mr. Yes, lordship.
yes. Complied with?
Implies, yes, Lordship. Ye-
Was directed to renew the sanction
Yes,
plan.
Lordship.
Uh,
Lordship was directed to set aside the 30th August 2017.
the learned none appears for the petition at the on the next matter. Item number 568.
My lord, I am appearing for the petitioner, my lord. Your lordship, kindly see the last order of your lordship. My lord, they stated they file a SLP before the Supreme Court.
Then I'm
But-
adjourning it.
No matter what happened, SLP still defective. But on the other hand, KMDA filed one SLP that KMDA filed another SLP that was hard notice issue. Order was passed. This is the situation of this case.
Then I'm adjourning it. Order is nobody is appearing.
Nobody is appearing. But we have complied with, my lord. That is
complied.
We have complied with, but the issue is pending to the, my lord. It is up to the department now. The land, your lordship directed us to send a requisition to the department, my lord, to acquire the land. Now we send the requisition. Now there was a meeting, my lord, held by the committee of
The petition, none appears for the petition. Next matter.
One 71.
Which is an assigned matter?
193.
193.
But I have given notice, my lord, for 194 to be mentioned at 3:15 p.m.
194 to be mentioned at 3:15. Why 194? What is there?
My lord, this is the matter, my lord, the order 12A matter, order 13A. 13A matter, my lord.
তিনটে কোনটা?
এটা কার matter? ও আমাদের তো করে গেছে তো 193 করে দাও।
So you are appearing in 193 also. So that's the fixed matter. No, I was under the impression it's that matter. The commercial court.
That's 194.
Oh, that's 194.
I have given notice, my lord, so that it is taken up, my lord, also.
Can be taken up, no difficulty on that.
Lordship.
Other side was
Subject to your other side coming.
Yes, yes, yes.
Yes. Your choice.
No, 190.
193, I'm for the petitioner. I have some instructions, Lordship. Because of pendency of this matter in all other proceedings, the yes. So,
If you want to
So I believe other matters are released. 3:30.
থাকো না।
একটা বারে আমার তো হবে, আমারটা তো করতে হবে।
Mr. Mitra has two matters.
হ্যাঁ।
Not complete.
এটা কি উচিত হলো দাদা? কেন? আমি করিনি।
Lordship, the next matter could be taken up any day next week, my lord. I don't know.
You have concluded your argument. It's Mr. Mitra who will be replying.
I have to
Very well,
distinguish
very
three cases.
Yes.
That's it.
What's the difficulty?
Very well, my lord.
Any one of you have 3-4 advocates there. Anyone can remain.
Very well, my lord.
briefly, this is, I have come up against an order whereby my application under Order 7, Rule 11 has been rejected. Lordship, primarily, I will give your Lordship a
Order 7, Rule 11 rejected. What is the
rejected
suit for?
suit for specific performance of a contract with a bank. So, Lordship, the contract,
What's the contract for?
may I place that, Lordship? The contract, they say that there is a contract. We say there was never any contract. So, we say that there is no cause of action in filing the suit at all. Now, the cause of action they claim is that the bank had in 2017 floated an offer for one-time settlement. Now, the bank had specifically mentioned that these are the criteria. If you agree to these criteria, 1, 2, 3, 4, you can avail the OTS at this and this amount. If you do not agree to the one-time, if you pay within a certain date, the amount will even get further reduced. Along with the OTS proposal,
with
certain terms and conditions. And we said that if you agree, you may offer for a proposal. You may offer the proposal. Now, they are the guarantors. They have executed personal guarantees, the plaintiffs before your lordship. One is the company and one is one is the director. He has no, the borrower is a different, but the guarantor is, one is the corporate guarantor, the petitioner, the plaintiff number 1, and the another guarantor, he is the director of the other company. He also executed a personal guarantee. The plaintiff number 1 company, the borrower is different, lordship. They are pro formas here. So now they submit a proposal where they say, yes, we agree to the amount and we agree to pay the upfront, we agree to the date, everything. But 2 points. 1, we want inspection of all the title documents held by you. Second, he says that once I pay, I want that I will exercise my right of subrogation. All the title deeds which are held by you with the bank should be given to me.
According to you, that's counter offer.
Absolutely. So a counter offer is made. We go through the offer. We receive, they also make that upfront payment. And in the upfront payment, while I will place the letters, it has been repeatedly notified to them by the bank that this is the amount which you pay for processing the settlement. I will place all the correspondences because that is only what your lordship will look into, that is annexed to their plaint. I will not go beyond that. Ultimately, bank refuses in express terms. Bank refuses. Bank even reverts or credits back the amount which was deposited with the bank towards the OTS. Now they come up, they start writing letters that there has been a concluded contract with the bank you have violated, you are wriggling out of the contract, and they ultimately filed this suit in 2018. No notice served on the bank, no injunction application moved. In 2022, they attempt to move an injunction application before the learned trial judge. The learned trial judge rightly says that there has been under order records that not even notice or summons have been served on the bank. In 2022, when there have already been a lot of sales and other of the assets which they claim that they should have the right of subrogation and they claim injunction. That notice is served in 2022. We entered appearance and we filed this Order 7, Rule 11 on several grounds. I will just very briefly indicate. First is the
Where is the impugned order?
impugned order, Lordship.
Impugned order.
Impugned order is, it is a longish order, Lordship. It is at the last of the civil revisional application. It is a little longish order.
The longish order, it's a
Yes.
well-reasoned order then.
Lordship will kindly hear me, and then Lordship will come to the, because out of the other submissions, the main
Order dated 11th
11th
May
of
2023.
May 2020.
By this time, the suit could have been disposed of.
Lordship most respectfully no. Lordship is not aware of how many proceedings is going on between the bank and this versus. না এটাও হতো না দাদা 18 suit 22 Lordship, I will place the order. Lordship, may I first place the plaint? Lordship will kindly permit me. I have prepared a list of dates for convenience. The list of dates. List of dates for convenience. I will just place. Lordship, the facts, Lordship has.
What is the scan for?
Lordship,
Can
there are
one, can five.
Lordship, there are applications. First, when we moved this the civil revisional application, they took out one application for vacating our interim order.
So there's an interim order.
Yes. Now, and there is also another application which we have taken out, praying for vacating an order by which they are enjoying injunction against all the properties, all the security.
Application to Swaranto double
Huh.
volume hoye gache.
Out the revisional application.
No, I was trying to get an idea that how to reduce the volume of the civil revision application. It's very difficult to keep all the papers here. Yes.
Lordship, this is just for convenience, Lordship. I will just Lordship, no. Lordship, I am under instruction. Lordship will kindly. আমি কিছুতেই ছাড়বো না, কিছুতেই না। চেষ্টা তো করি।
Anything from your right ears because
I know,
all
I know.
senior advocates on your right side.
I know that. Lordship will. This is the plaint. Lordship will
Yes,
kindly.
he wanted to give a list of dates.
I have given. Just handed.
List of dates to him.
একটা ছোট and other consequential reliefs. Lordship, instead of placing the plaint, Lordship, may I directly go to the annexures? If your Lordship will permit me, Lordship, I'll just place the reliefs prayed for first, and I'll take your Lordship to the annexures with the plaint. The relief is declaration that letter dated 10/11/17, these are the letters, are bad in law and not binding. Decree for perpetual injunction restraining defendant number 1, main agents and servants from acting in breach of concluded contract as pleaded in paragraphs above. Decree for specific performance of concluded contract as pleaded in paragraphs this. Alternatively, for a decree of permanent injunction directing defendant number 1 to accept a sum of 8 crores and odd from plaintiffs in full and final satisfaction of the claims arising out of loan account this and this. Now, Lordship will directly.
What is your claim?
I have a decree in 2011 of 19 crores and odd. And that decrease from the DRT, Lordship, there are other facts, but primarily since there are now several judgments which have come up because of, I will have to first place this, then I will place all the other facts. The decrease there, only the recovery certificate was stayed by the Honorable DRT because the decree was ex parte. Thereafter, there was an appeal before the DRAT. The Honorable DRAT has only affected the stay in respect of the petitioner, the plaintiff number 2 herein, who was the respondent number 3, I believe in that. So ideally that there is no appeal against the judgment, only the recovery has been stayed only against this person. So that was also one of the grounds, and most of the order mostly records on the res judicata issue and these, not entering into the main crux of the case that there is no cause of action in filing the suit at all. Lordship.
Cause of action meaning thereby you say that there is no concluded contract.
Concluded contract, no contract at all. We say that.
Yes.
Lordship, at pages 59
Yes, 59.
to 61 are two similar letters which were subsequently withdrawn by the subsequent letters. So I'm not placing these two letters. Lordship will kindly come to page 65. What is the proposal? Which is this? This was the proposal of the bank. Attention, this and this. State Bank of India has come out with a
specific performance of these letters.
Yes.
Declaration that these letters
yes.
are bad.
Bad. The letter by which we say that there is no agreement, we return the money, those declarations. And for specific performance of concluded contract on the basis of these letters.
There was no agreement.
Nothing.
So according to them, concluded contract by virtue of exchange of letters.
Absolutely.
You show me those letters.
Yes, that is what I'm directly on. I'm directly on that.
Page
65 onwards, Lordship will kindly take.
First letter is 30th of November 2017.
No, for Lordship, that letter is subsequent. Lordship will not look into that now because the serially may I come. The first letter for settlement was of 8th of September 2017, which was subsequently withdrawn by this letter at page 65.
So if it is withdrawn,
no, that I'm not placing. It is part of the plaint. I have annexed. That is why.
All right. So
yes.
What is the relevant according?
Yes. From here onwards, all are relevant, Lordship. Only the communications.
From where?
65.
65.
Yes.
All right. So 15th of September 2017.
Yes.
Yes.
Now the bank says State Bank of India has come out with a scheme for one-time settlement of non-performing assets 2017. In this connection, we would like to advise you that your dues to the bank are eligible for settlement under the SBI OTS 2017 on the following terms and conditions. Ledger outstanding, excluding accrued interest from the date of NPA as on 31/3/2017, 13 crore and odd. Amount of OTS 9 crore 64,070,563. Application for OTS, Lordship will mark this, will be processed only on deposit of minimum 10% of the ledger outstanding as on 31/3/2007. So here I pause for a moment. We say application for OTS will be processed. 25% of the OTS amount will have to be deposited by you as upfront money within 30 days. Again, Lordship will kindly mark from the date of sanction of OTS.
So various stages.
Yes, there has to be a proposal coming from them. Then we will process it. Then there is a question of sanction.
Yes.
This would include the amount deposited by you along with the application. The balance amount can be paid within 6 months from the date of sanction of OTS. So the stages are mentioned. From the date of sanction, you will pay, the balance will be paid together with this and this. However, interest will be charged. I'm not placing that. Then 2, where applicable, I say it is applicable here. Since your case is pending before court, Lok Adalat, DRT, any settlement will be subject to filing of consent terms for consent decree, necessary orders from court, Lok Adalat, DRT, and this letter is without prejudice to the rights and contentions of the bank in the said proceedings. Since you have issued notice under, you have been issued notice under the Securitization Act, this notice is without prejudice to our rights to take or continue actions under the Act, unless a compromise is settled. Lordship will mark this under the present SBI OTS 2017 scheme as stated above. Please advise your willingness to settle. So an advice is sought. The dues by 31/10/2017. Your request for settlement will be processed for acceptance or otherwise. Both processed for acceptance or otherwise on receipt of your communication and deposit of minimum 10% of the outstanding as on this and this. So it will be processed on for acceptance or maybe otherwise.
All right, what happened after this?
Yes.
In reply, what happened?
Lordship, the first reply letter, Lordship, there are two identical letters, so I'm skipping that. Now, Lordship will come to 71. 30th October 2017. Lordship has got that. The learned advocate for the plaintiff say, my clients, without prejudice to their rights and contentions in the pending legal proceeding, including the contention that my clients are not liable to make any payments, are willing to make payment of one-time settlement amount of this and this as offered. In the subject letter, they acknowledge that this is an offer. Now they say, in terms of the caption letter, please find attached here with a copy of check. They submit a copy of the check for the time being. My client shall hand over the original check on the following. Now they qualify it. Inspection of original documents of security as per list attached to OA number this and this filed by you. Confirming that upon acceptance of the OTS and subject to payments of the balance sum of the OTS. So they understand that there has to be a process where the bank will accept the OTS. All original documents of security as per list attached in OA number this and this filed by you pertaining to loan transaction, including all original deeds of all the properties and securities against the caption loan account by which mortgage and security has been created. Now C, Lordship will kindly mark this. In case OTS is not accepted, the amount paid by my clients in terms of your offer contained in the letter dated this and this is refunded and shall not be adjusted and or appropriated in any manner whatsoever. So they say that if you do not accept the OTS, so they understand that there is a process of consideration. Now, Lordship will come to the letter at page 74. This is again the letter by the learned advocate. I'm not placing the entire thing, not very pertinent. But third paragraph, sir, further also request of my earlier letter, you have not given any inspection in spite of visit of my client's representative to your office, nor have you consented to the terms of the letter. So they say, they agree that you have not consented to the terms of the letter. Then they say that kindly give inspection of the properties. The property was inadvertently not included in the list annex. This and this, Lordship, not very pertinent for the present consideration. Second page. Kindly note that under provisions of law, my clients would become entitled to all rights and benefits that you have in respect of the entire loan amount, including those in respect of securities and properties held by you against the loan, and all such rights would stand assigned and vested in my clients. In such circumstances, kindly ensure all requests made in my previous letters are complied with prior to deposit of check already sent to you. In case any further clarification on the issue is required, kindly let me know prior to deposit of the check. I will show where we let him know in the self-same letter. Lord, I will come. Please further note that since my client has agreed to the offer made by you without any bargain or remission on the amount offered by you, question of now considering whether you would accept the OTS or not does not remain. He says that there is no, it does not remain. Now, Lordship will kindly seize the previous page. Now this is received by the bank's officer. He says, received subject to terms and conditions discussed earlier. Inspection of documents can be had on this. We reiterate that the dash of is to be deposited, the upfront amount is to be deposited as on 31/10/2017. This is refundable if final OTS is not approved. So he says you don't deposit. On receipt of the letter, the bank clarifies that this has to be paid. If this is not paid, then we cannot process it, because the earlier letter will, Lordship has, I have placed that in the earlier letter, we say for purpose of processing that amount is required. Now this, he says that does not mean that it is approved. It is received. Second, again, page 76, Lordship will kindly take a subsequent letter by the learned advocate. In continuation of my previous letters, both dated this and this, caption, in view of the offer made by you and proceeding on the basis that the requests made in the said letter dated this and this shall be adhered to by you, I have on behalf of my clients already sent you the original check drawn on this and this. Again, while receiving this, the bank has given the note that on payment of upfront does not mean that the OTS is accepted. Discuss with advocate, upfront is accepted subject to fulfill of the terms and conditions, and also discussion with client if required on the, his Hive said in letter, Lordship, I cannot, his something raised in your letter today on this and this. The second page says, since today is the last date for my clients to pay OTS amount, I have till now not received any reply from your end to my above letter dated this and this. My clients are willing to transfer the amount to you through RTGS in course of today. Please let me know if you are willing to accept the same, and in token of acceptance, kindly issue a letter to enable my clients to make payment. So he knows that he is in the negotiation stage. He says that if you accept, you let me know that you are accepting this and issue a letter. He says then kindly issue a letter. Then Lordship, again, Lordship will come to subsequent letter by him. The bank at page 78, 3rd November. Please refer to the caption letters, this and this and this. I visited your office on this and this. Unfortunately, I was informed that due to an ongoing audit, inspection would not be possible, and you agreed to provide inspection somewhere this. My clients have agreed to the OTS request to ensure that inspection of all documents relating to the loan, including mortgage deeds and security documents as per the particulars enclosed in my earlier letters. Since my client would be entitled to receive all such documents, it is pertinent to state property at Katihar is charged in security to the said loan. As already discussed, my client is getting the draft of the terms of settlement prepared, which shall be forwarded to you for approval. Lordship will kindly mark this. Similarly, all forms of assignment of subsisting charges, file this and this, not relevant. Now, this is the page 80 is the letter of the bank. Lordship knows that bank has a process where bank needs to place everything before the concerned departments, authorities. On 18/11, bank comes back. He says, we refer to all the communications received through advocate Indudip Basu regarding settlement of account of Messrs. Sun Biotechnology Limited. In this connection, the upfront amount of rupees this and this was received by us and is held in Nolian account of the authorized officer. This amount as upfront will be refunded if final sanction of compromise is not accorded by appropriate authority. We have to advise as under. The offer should come directly from guarantor, corporate guarantor supported by resolution and not through any power of attorney holder. Second, the inspection of documents is possible in your presence. In case the account is being settled under compromise, title deeds will be handed over to the respective mortgagors against proper resolution and acknowledgement. Lordship, here I pause for a moment. This means bank says that we will not be able to, you had given a counter offer that the documents have to be handed over to me, to you because you are paying, you want to exercise your right of subrogation. Bank has considered this. Bank has held your money in no-lien account for the purpose of processing the settlement. The settlement is not arrived at, that amount will be refunded to you. Also, we say that the offer should not come directly from the guarantor, or so we do not even acknowledge that there has been a very valid offer, but I will not press on this much. The inspection of documents is possible in your presence. Out of the clauses he has proposed, inspection we agree. We agree to give an inspection, but we say that in case the account is settled under compromise, title deeds will be handed over to the respective mortgagors against proper resolution and acknowledgement. So we refuse his terms of the offer. We say that we will return it to the respective mortgagors. As per your letters under reference, property at Katiyar, original deeds are not with us and requires further clarification. Please note, bank will not stand committed to anything about right of subrogation against the company or other guarantors. NOC in standard format will be issued. One of the property being sold and this is disputed by the buyer and the matter is sub judice. This needs further discussion. We are of the view that the matter can be further clarified by scheduling a meeting at a convenient time and place. And this will also facilitate drafting of consent decree and discuss the terms of compromise in details. So even at this stage, we make another counter offer. See, we gave you an offer. You qualified that offer in return. We are now further qualifying that offer. We are saying that this part of your offer can be accepted. The remaining part cannot be accepted. Now we also invite them. Please come and we will discuss the consent decree and finalize the terms of the settlement. So it is understood that there is no contract arrived at between the bank and the borrower. Now at page 81, Lordship, there is now numerous correspondence, Lordship, will be. The undersigned is in receipt of your letter date and noted contents therein. I am attaching my authority letter resolutions to act on behalf of my clients along with letter dated this and this issued by Mr. Ghansham Sharda for your perusal as required in point number 2 of your letter. You can consider the same, such as there is no bar in law for advocate to represent his clients who are guarantor or corporate guarantor of a bank. I would request you kindly reconsider the fact, Lordship will mark, kindly reconsider the fact of giving me inspection of documents by me as according to law guarantor who pays the debt steps into the shoes of bank. Hence, you should hand over to my clients the mortgage documents since they are unwilling to pay the rest settlement amount. Regarding Katiyar property, my client has had only cause to be given possession. This is not relevant. Office has this and this is not subject matter of settlement scheme. There is no requirement at this stage to discuss about the said property in the settlement scheme. So he again acknowledges that there is no settlement, there is a proposal, there is a negotiation stage which is going on with the bank. My client has been traveling for business meeting. He shall sit with you only at, now Lordship will mark, the time of finalization of the settlement procedure. Hence, I have been authorized to carry out the initial discussions or procedures with you. Initial discussion or procedures with you. So he agrees and very well understands that this is what is a negotiation ongoing. Now, Lordship will take up the page 85, which is directly the letter from the plaintiff number 2. He says, in your above referred letter dated this and this, you have conveyed that the offer should come directly from guarantor, corporate guarantor, supported by resolution and not through power of attorney. In view of the letter, although my authorized representative and advocate, Mr. Indudip Basu, has already sent you an acceptance of the scheme and also a check for this and this, along with acceptance of terms and conditions of your letter, but in order to satisfy and complete the offer, Lordship will kindly mark this. Once again repeat and reiterate that I accept the terms of the letter dated 15/9/2017. I further place on record that I, along with this and this letter sent to you, has been deposited by your client and credited. As informed to you earlier, once again, Mr. Basu will be representing on my behalf for inspection of records. Now, Lordship will come to 8th December. Next letter. My clients are thankful to you for receiving and encashing my client's check being this and this forwarded to you upon the agreement being arrived at between yourselves. Now he says that agreement has arrived at. This is from where the learned advocate says that there has been a concluded contract. My clients whereby and whereunder my clients and yourselves had agreed to close the loan account on mutually agreed sum of this and this, my client being entitled in law have time and again requested for inspection of original documents and also delivery of the same so that my client could pay the balance of the agreed amount. You will appreciate that my clients have been ready and willing to perform his part of obligations under the agreement arrived at. In part performance of such agreement, my clients had made payments as aforesaid, and in part performance of such agreement, you have received and accepted the payment and encashed the check. You are therefore requested to forthwith perform the remaining obligations under the agreement and inform as to when my clients are required to deposit the balance amount, particularly when such final payment, original title deeds and documents are to be received from you by my clients. So he reiterates that no, now there is an agreement, and the agreement he says that you have to give the documents where there is an express denial by the bank already with them, which they have duly received. But he says from here they completely take a stand that no, there is a concluded contract entered into with between the parties. Now, by the next letter, that is at 30/11/2017, Lordship, this was possibly sent on 8th of December. That is why it is coming later in serial. And
this was sent after that.
After that, but the initial letter was already there, where we have said that this is what we can offer. Yes. And he again says that no, you have agreed to this, and you have to give us the title deeds. Even in the last letter, he says.
Yes.
Now, Lordship will take 30/11/2017 at page 88. With reference to the OTS offer submitted by you, along with upfront and various discussions and communication, the proposal is declined by appropriate authority as the terms and conditions proposed by you are not accepted to the bank. In view of above, we request you to advise the account details for refund of the upfront amount. Now, these are the similar letters sent to both the guarantors. Now, 1812, again we send one letter. We say that with reference to your letter dated 8 December received by us on 11 December, would like to draw your attention to our earlier letter number this and this. We again request you, so that letter was received by us later on 11th. We again request you to give account with bank details to refund the upfront amount to you. Now this letter comes 9/1/2018 at 92. Your bank came out with a one-time settlement of NPAs and OCAs in manufacturing trade this and this. The said offer was made to all the NPA accounts, including this and this, Sun Biotechnology. Copy of the said offer made to Sun Biotechnology was also marked to various companies, entities who were part guarantor to the loan given to this and this. The company and Mr. This and this duly considered the offer by your bank and accepted such offer by furnishing check of this and this issued by Mr. This and this towards deposit of minimum 10% of the outstanding amount as on 31/3/2017 in terms of the offer. Accordingly, on acceptance of the offer, it became a concluded contract. He himself says, we understand that almost all NPA accounts of the nominees who express our requisite amount to accept such offer have been finally this and this. Then he comes to the last paragraph. I'll place no reasons whatsoever have been given in the said letter dated 30/11/2017 for rejection of the offer. It is unfortunate that all of a sudden OTS made by bank was acted upon and Mr. This and this was ready and willing to deposit the balance amount in terms of the OTS amount within the stipulated period. Your bank apparently returned the said amount of the this and this in the bank account of Mr. This without assigning any reason. Please note that with the acceptance of 10% of OTS amount by you, there came into existence a valid contract between the parties which could not be breached in an unilateral manner as has been done by you. Your letter dated 30/11/2017 purporting to cancel the OTS is illegal, arbitrary, and not binding on us. Such a concluded contract could not be rescinded and or terminated. It appears that you have deposited the amount in the account of Mr. This without any prior notice to him of the amount which was paid by him to you on account of OTS. The said amount having been already deposited in the account of Mr. Sharda without affording an opportunity to him object to the same is illegal, and such deposit is being accepted to us without prejudice to our rights and contention. So he agrees that bank has already refunded that amount, so that is not subject matter in dispute. Now the bank replies at page 95. With reference to your letter number nil dated 9/1/2018, we have to advise you that OTS offer made by you and Mr. Sharda as one of the guarantors to the borrower company, this and this, is not accepted by the bank for the following reasons. Via letter dated 18/11/2017, we have informed the terms and conditions stipulated by us for your consideration of OTS proposal submitted by you and for acceptance. It was made very clear from time and again that the acceptance of the upfront amount before the cutoff date does not entail any acceptance of compromise offer, but it is subject to final sanction from the appropriate authority. In case of non-acceptance of OTS proposal submitted by you, then the upfront amount will be refunded. Thereafter, a meeting with Mr. Sharda was held at his office regarding OTS proposal. However, he did not agree to deliver the original deeds to the respective parties. Rather, he insisted to deliver all the original title deeds to him instead of the respective mortgages, which is not acceptable to the bank. No viable solution was worked out in respect of the property sold being office space, this and this, being disputed with the buyer. This has a direct impact on the compromise amount offered by you, and this, in view of the above, offer was not accepted by the appropriate authority and which was communicated to you and Mr. This and this via letter dated 30/11/2017. Upfront amount of this was refunded. Hence, we are unable to withdraw the letter dated this and this. So these are the series of correspondences which are exchanged between the borrower and the guarantor and the bank, guarantor borrower, whichever. He proposes an OTS. We float.
According to you, there was no concluded contract.
Absolutely.
Because there were only offers and counter offers.
Absolutely.
No, parties were not addendum on certain terms and conditions.
Absolutely.
That's just.
This is my.
So now please take me to the impugned order.
Yes. Should I place the entirety of it?
So the relevant part, because the facts you have placed.
Decisions.
Now the.
The decisions relied on by the defendant, this is relied on. I will directly come to the portion where the cause of action is discussed first, then I will take to the remaining portion.
Which page?
Lordship, it starts on from internal page 3.
Yes. Yes.
No, Lordship will kindly take from internal page 2 from the last paragraph, maybe. Yes. It is now settled proposition of law which has been emphatically elaborated by the various judgments of the Honorable Supreme Court of India that at the time of consideration of application under Order 7, Rule 11 of the Code of Civil Procedure, praying for rejection of plaint, sole consideration will be to look into the plaint only. Facts made in the written statement and even facts stated in the application for rejection of plaint are not to be looked into, not disputed. Whether the plaint discloses a cause of action or not is essentially a question of fact. However, whether it does or does not must be found from reading of the plaint itself, during which the averments made in the plaint in their entirety must be held to be correct. In other words, plaint must be construed as it stands without addition or subtraction of words. plaints providing a prima facie cause of action are not to be simply rejected at the threshold. Rejection of a plaint is a serious matter as it non-suits the plaintiff and kills the cause of action. The court has to see whether the claim made by plaintiff is likely to succeed. It is merely to satisfy itself that the allegations made in the plaint, if accepted as true, would entitle the plaintiff to the relief he claims. If accepting those allegations are true, no case is made out for granting relief, no cause of action would be shown and the plaint must be rejected. In ascertaining whether the plaint shows a cause of action, the court must not enter upon a trial of the issues affecting the merits of claim made by the plaintiff. It cannot take into consideration defenses which the defendant may raise upon merits. If the allegations in the plaint prima facie show a cause of action, court cannot embark upon an inquiry whether the allegations are true in fact or whether the plaintiff will succeed in the claims made by him. Therefore, so long as the claims disclose some cause of action or raises some questions fit to be decided, the mere fact that the case is weak and not likely to succeed is no ground for striking it out. It is matter on record that defendant bank had filed one original application before the Debts Recovery Tribunal to the bank against the borrowers and guarantors of the loan account, which has been decreed in favor of the defendant number 1. This is also a matter on record that during pendency of the original application, defendant number 1 had on 15/9/2017 given an offer of one-time settlement. The one-time settlement amount was for this and this, and it was paid. If it is paid within this and this, then the one-time settlement amount will be reduced to this. In the letter dated 15/2/2007, defendant number 1 bank has also made it point that the application for one-time settlement will be proceeded only on deposit of minimum 10%, that is rupees 1,37,000 lakhs and odd. Plaintiffs accepted the offer and tendered the sum of this with a check number this and this. Defendant accepted the check and encashed the same. And according to plaintiffs, a concluded contract was entered by and between plaintiffs and the defendant number 1. Instant suit is filed by the plaintiffs for specific performance of concluded contract. Plaintiffs have filed the suit for specific performance of contract under provision of Specific Relief Act in the year 2018 within the statutory period of limitation. In the meantime, on this and this, the tribunal has allowed the claim of the bank against the borrowers and guarantors. The fact of filing of a case for vacating ex parte order by plaintiff of this suit has also come before this court by filing an order dated this and this passed in connection with NDN number filed by the plaintiff. Honorable Court by order has been pleased to keep the recovery certificate in abeyance till disposal of the MA. Now, whether the relief sought by plaintiffs regarding specific performance of contracts is barred by any provision of law resulting into rejection of plaint is required to be considered. The relief sought for by the plaintiffs by considering the letter dated 15/9/27 to be an offer by the defendant number 1, which was duly accepted by the plaintiff by performing the part performance as per the offer, whether will amount to a concluded contract or not is a matter to be decided in trial. Whether the matter could not be brought before the Debts Recovery Tribunal has to be the prime consideration. If it can be proved that the question of dispute which has been raised by plaintiffs in the suit could have been placed before the learned Debts Recovery Tribunal and there was adequate relief to the plaintiffs, then this suit can be considered to be expressly barred by provisions of law of the RDB Act or the Securitization Act. In the suit at hand, there is no averment of plaintiffs regarding practicing any fraud or misrepresentation. Admittedly, the letter...
Consider order, what is the submission on this?
Yes. Lordship, my prima facie submission, Lordship has understood that there was never any concluded contract. Now, Lordship, I have prepared a compilation of judgments which I want to rely on. Should I start with those today?
Yes.
What? Take your hand.
The submission only on failure to disclose a cause of action or also on that the suit is barred?
Lordship,
the provisions of the recovery of debts. And
Lordship, now there are contradictory judgments which have come up. I will not want to enter into that side because I know that there are several judgments now where they say that the Honorable Supreme Court has settled that it is maintainable. Although I say that there is a point on res judicata, but then there is again one judgment which says that res judicata will be decided at the stage of trial, and that I really do not want to lay much emphasis on that, but I will place.
This one-time settlement and issue before the tribunal? No.
No. That was
that
not.
is not the issue. How can
Yes.
it be a res
So
judicata?
that is no res judicata only in the sense that there is already a decree, but that is why I am not pressing so hard on those.
There is one way of looking at it, saying that res judicata cannot be decided at order 11 stage. That's one part, whether it can or cannot be. But even if it is accepted that it can be on the basis of these documents, but this one-time settlement issue was not an issue before the tribunal.
Yes.
That
And
is not so. Res judicata may not be.
such may not come up, but the primarily I say that there is
Failure to disclose a cause of action.
absolutely there is no cause of action at all.
Yes.
Lordship, may I?
Which decision you want to rely upon?
Yes. Lordship will.
All on same points.
No, not all on same points. The first two are on the what constitutes a contract. First,
Yes.
yes.
That's important.
Yes. Lordship will kindly take up the first judgment. This is 1954 to SCC 728. Here, Lordship, it has been dealt with in detail. So, may I indicate the paragraphs? From paragraph 23 onwards till paragraph 31.
Yes.
Yes. Lordship, paragraph. This appeal raises a very short point as to whether a contract arrived at between the parties was a concluded contract. Our judgment is confined on this point. Preliminary issue naturally assumes that there was an offer. 23. Page 9. Internal page. With the pagination করা আছে স্যার আপনার ওইটাতে। On assumption without deciding the other issues which contend that there was no offer because the stage of I am not on this. Yes. Lordship, I am not placing the facts of that. I am just directly coming to paragraph 25. But there is much more in the proposals than para A and the three options. There are at first conditions in the preamble. There is less para B. There are also further conditions set out for further clarification part of the document. Lordship, that is not required. 26. Learned counsel for the plaintiff argues that it is not the way to read plaintiff's letter. Proposals contain two main alternatives, cash side, property side. This is also in fact, I will not trouble your lordship with this. But that will be relevant because of understanding what has come. 27. We cannot agree if the case at hand to be that not relevant. 28. It is argued on behalf of the plaintiffs that para B does not logically belong to property side of the proposal. It is an obligation cast on cash side and should have been included. Therefore, a duty is cast on courts to do that which parties really intended and recast the document in form which makes sense and best carries out real intentions. Reference was made to the House of Lords decision in Hillas and Company Limited versus Arcos Limited. It is, we think, bootless to examine the scope of these rules because the first effort of the court should be to give effect to the document as it stands. And if it makes sense as it stands, no court can invert the order of the words or recast them so as to give them some other meaning. Here is a document put forward by the defendants. They choose to place para B under the conditions to be imposed on the property side. It makes sense as it stands and where it stands. It is a qualification of what is conferred in wide terms in para A, and it is a logical to place it under the heading of other side and would be to place it among the rights conferred on the cash side. The party drawing up the documents choose to do this. Why should an effort be made to recast his writing in invert the order of paragraph simply because plaintiffs choose to accept in terms which leave them at almost foolproof loophole for repudiation of the obligations imposed of them should it turn out to their advantage to do so. What could have been easier than to say that they accepted the proposals as a whole and chose the property side, or if they wish to be specific, to say that they accepted both paras A and B and the rest of the obligations passed on them. After all, why do the plaintiffs strain to recast this document except to shift the emphasis and introduce ambiguities which are not there if the document is left alone? What the plaintiffs say in effect is this: leave this document alone and it is us, because our acceptance was not in terms in which the offer was made, but we intended to accept. Therefore, to give effect to our intentions, you must recast the order of proposals, and then, because that introduces ambiguities, you must look to the subsequent conduct of the parties, and from that it is clear that we intended to accept, and the defendants understood that we accepted and tried to back out. But that is not what we have to see. Our duty is to find out what the plaintiffs thought or intended, but to decide what was the offer which the defendants made and whether the plaintiffs accepted in terms in which it was made. What is there ambiguous is one party say, I offer you A subject to the limitations set out in B and C. Surely it can only mean one thing, namely exactly what it says. And if a person say, I accept A, how can it be said that he accepted the offer in terms in which it was made? On the face of it, and if you stop there and know nothing else, it is not the answer plain that the offer has not been accepted in its entirety, and that therefore what the plaintiffs choose to call an acceptance is no acceptance at all in the realm of contract. And if that is the only reasonable construction when nothing else is known, and it is possible to give clear effect to the words as they stand, how can an ambiguity be introduced by extraneous material and recasting of offer by looking to subsequent conduct? We agree with the learned Chief Judge that there is no ambiguity here and there was no scope of acceptance in law sufficient to conclude a contract.
So this is the ultimate thing, paragraph
Yes.
30. So we have to see whether the offer was anything
Yes.
subject to something.
Yes.
And what was the
Yes.
acceptance.
Yes. So qualified. Lordship, which is the second judgment is in much more clear terms. Lordship will kindly take up 2021 3 SCC 24 from paragraph 41 onwards, 44 onwards. Sorry. Observing that the main submission made on behalf of the respective parties before the High Court swirled around whether there was any concluded contract or not, High Court noted following judgment cited on behalf of the applicant in this regard.
41.
44, paragraph
44. Yes.
Yes. Regard. In the judgment and order under appeal, High Court has not discussed any of the judgments referred. High Court simply recorded the contention of the Lordship will kindly permit me. Yes. Contention of the appellant that there was no previous approval of the Board of Trustees and therefore there was no enforceable contract. Now, the reasoning, Lordship will kindly take paragraph 52. 53. Trial court has relied on section 4 of the Contract Act but completely overlooked section 7. I am on section 7 completely from the inception there. Section 7 on the contract is set out herein below for convenience. In order to convert a proposal into a promise, the acceptance must be absolute and unqualified, be expressed in some usual and reasonable manner unless the proposal prescribes the manner in which it is to be accepted. If the proposal prescribes a manner in which it is to be accepted and the acceptance is not made in such manner, proposer may within reasonable time after the acceptance is communicated to him insist that his proposal shall be accepted in the prescribed manner and not otherwise. But if he fails to do so, he accepts the acceptance. Now, there are two parts of this. One, that it has to be absolute and unqualified. And second, if you say that a proposal is to be accepted in a certain manner, then that has to be accepted in that certain manner. And a third part says that if you do not within a reasonable time communicate that reasonable time after the acceptance is communicated, insist that the proposal shall be accepted in a prescribed manner and not otherwise. And if he fails to do so, he accepts. Now, I have shown The stages, Lordship, I have completely shown that what are the stages. In all the documents, it is understood the stage of negotiation. We say that this is the OTS scheme which has come out. They say this is the proposal. The nature of the proposal is this. You have to give me the deeds is one of their qualified offers made. We consider and we say that we cannot do that. So that is also communicated to the
According to you, the parties were not ad idem?
Not ad idem at all. Now, it is a cardinal principle of law of contract that the offer and the acceptance of an offer must be absolute. It can give no room for doubt. The offer and acceptance must be based or founded on three components, that is certainty, commitment, and communication. Lordship is on 54?
Yes.
However, when the acceptor puts in a new condition while accepting the contract already signed by the proposer, the contract is not complete until the proposer accepts as condition, as held by this court in Harvinder Singh versus Bagun Sambrui. An acceptance with a variation is no acceptance. It is, in effect, a substance, simply a counter proposal which must be accepted fully by the original proposer before a contract is made. In Union of India versus Bhimsen Valaiti Ram, a three-judge bench of this court has held that acceptance of an offer may be either absolute or conditional. If the acceptance is conditional, offer can be withdrawn at any moment until absolute acceptance has taken place. In Jawaharlal Burman versus Union of India, referred to by the High Court, this court has held that under Section 7 of the Contract Act, acceptance of the offer must be absolute and unqualified, and it cannot be conditional. However, in the facts and circumstances of that case, on a reading of the letter of acceptance as a whole, appellant's argument that the letter was intended to make a substantial variation in the contract by making the deposit of security a condition precedent instead of a condition subsequent was not accepted. High Court also overlooked Section 7 of the Contract Act. Both the trial court and
Those were on facts.
Yes. Lordship.
How much time you will take?
Lordship, the other judgments I need to,
How much time?
I think I will take another 10-15 minutes, not more. Lordship, my main submissions I have made that I say there is no contract at all for maintaining a suit for specific.
When can you come back?
I can come back even tomorrow if your Lordship grants me. I am under immense pressure. I am expressing my mind, Lordship. Every proceeding is stalled because of they are enjoying an injunction from this honorable court. I manage করতে পারি।
I am not, my lord, really enjoying any injunction. What they obtained was stay of the entire suit. That was an ex parte order. Thereafter, my lord, my client had made an application that let them not deal with the properties. Because if the properties are dealt with, then the entire thing goes. That is the injunction which my client is enjoying.
Because of this, everything that covers everything, whatever security is held with the bank.
If I succeed ultimately, the suit would be dismissed because there is no property. That is.
Function you are enjoying.
Yes, the interim order is expiring tomorrow.
Both of you, because I've heard it sometimes she will be taking 10-15 minutes.
I will take some time.
How much time you will take?
I will take some time.
How much time?
The plaint has not been shown. That's the main thing.
Give me an idea so that I can post it. It may be sitting here and there, it can be, but
maybe my lord, 45 minutes to an hour. I'll try to restrict myself to 45 minutes.
নয় 10 11 তো আছি 12 থেকে আমি নেই বললাম পরে তাহলে একটু দেখি না এটা আমার পেটের লাথি পড়ছে এমনি দুটো লাথি আটকে দিচ্ছি আটকে দিচ্ছি
বারণ করেছি
কিন্তু আমাকে দিবি না আমি তোর আটকালাম
কবে থেকে নেই
12 থেকে 15 না না তারপরে রাখছেন তো প্রথম দুটো
17 রাখবেন 18th
বুঝতে পার ঠিক আছে
I was apprehensive because Mr. Roy will not be there, my lord, for some time. No, 18th is there. Yes.
বুধবার বুধবার
Lordship, only one.
He will be not available from when?
12 to 15 11 to 15 my lord I'm there on
11 to 15th he will not be available. So from 18th
Lordship,
to
may I humbly beseech one more, make a prayer, Lordship, that if my learned seniors can provide me a compilation of the judgments they want to rely on, then I can look into and we can conclude the matter.
খাওয়াবে না খাওয়াবে না
Give my side of it, there is no
খাওয়াবে না খাওয়াবে না
only to cut short the time, Lordship. I don't think I'm making a very unreasonable prayer.
একদম
That can be provided to me in the meantime.
একদম
Lordship will kindly.
direction can be
No,
passed.
Lordship may kindly. Yes, it is Lordship can kindly.
Between both of
request.
you, to that no order can be
Only to
passed.
the only to shorten the time before your Lordship, because I
extra
will
fee
need another day to maybe come back.
So is there
Mr. Ray is the problem
Mr. Rai is
The problem.
opposing, so when he is
Lordship, you can understand the imbalance. So that is why the imbalance
no
seems to be some.
when Mr. Mitso is there, he can be rest assured. So maybe he cannot commit something since Mr. Rai is.
Well, I'm very humble today, but the problem is, my lord, she took up one fee. Because today it was 3:30. She went on submitting after 3:30. So that would have been another day. So
What?
He was continuously telling me.
I'm grateful. Keep going.
ও আমার তো সাইড চেঞ্জ করতে হবে Before going into the three judgments, my lord, first submission was that, my lord, the suit has to be tried. Some prayers are left out. What is the prayer? Mean profit. That has got, my lord, nothing to do with the eviction part. Mean profit, my lord, if the eviction decree is passed, it has to be, my lord, there has to be some mean profit. That's only the question of calculation. Under order 20. That's it.
And mean profit is a subsequent proceeding altogether.
Absolutely subsequent. Absolutely subsequent. Now, next, my lord, it was submitted, my lord, section 114, right can be exercised at any stage.
That you are also not disputing even at the appellate stage.
I did not. On that account, for that, my lord, a decision was relied on, reported in 1986 Supreme Court cases online, SCC online 198. Sorry, Calcutta 198. 1986 SCC online Calcutta 198.
Shamlal Agarwal.
Yes. Kindly once come to my lord, paragraph 5.
Yes.
In the case at hand, Lordship got that. In the case at hand, the appellant tenant clearly committed a breach of the condition of the lease relating to payment of rent and obviously incurred forfeiture for such non-payment of rent, and Mr. Roy Choudhury, the learned advocate appearing for the tenant appellant, has fairly conceded that he is not in a position to assail the finding of the trial court that the lease to determined as a result of forfeiture as aforesaid. The defendant tenant, however, applied before the trial court for relief against forfeiture under section 114 TP Act, but his application was rejected as no interest on the rent in arrear as provided in the deed of lease was paid or tendered. Yes, an application was made. That application was rejected on the ground that, my lord, interest was not paid. Here, my lord, there is no application till date before your lordship. Forgetting about, my lord, the commercial court, according to me, the application ought to have been there before the commercial court, even before your lordship. There is no such application. Yes. Next, my lord, it was submitted before your lordship that, my lord.
What do you say to the decisions of the Delhi High Court on COVID-19?
I shall come to.
Because that decision which says 50%.
I shall come to that. Now, my lord, next it was submitted that, my lord, there was no reply to their letter. Firstly, my lord, I gave a notice. It was a composite notice. Now, my lord, some doubt was, my lord, sought to be thrown, my lord, on a composite notice. I had relied before your lordship a judgment of Bombay High Court which says composite notice is permissible. My lord, that was 1979 SCC online Bombay that I had placed before your lordship.
Yes.
Now, my notice, I can show your lordship, my notice says that you clear the dues within the time stipulated in the agreement, that is 2 months if I remember it correctly. If you don't do that, treat this as a notice for it's possibly 1 month and 2 months, whatever it is. 1 month and then 2 months notice for eviction. Now,
according to them, their argument is.
I was required to give further reply. I really
because according to them, you have said that please do rectify this breach.
Yes.
They said that because of this COVID-19 pandemic, I could not do this.
That was from the very beginning.
Explanation, according to them, you have to consider that and say no, this is not that. Then further notice. That's their submission.
I will tell your lordship, my lord, I did not place. If your lordship looks into the documents, my lord, lordship will find this stand was there before the notice and that was denied. Now, my lord, there is no point in, my lord, going on exchanging correspondence. My stand would be clear from my plate. I have made my stand clear in the plate. In my firstly initial letters, when they gave the letter arbitrarily, from tomorrow onwards, I shall pay you 2% or 1% of my total or the gross income. No basis. The force majeure clause, my lord, did not provide that. It's a contract between the parties. Force majeure is, if your lordship is pleased to, force majeure clause. If your lordship is pleased to come to the lease deed once, which starts at page 66, at page 81.
Yes. Wholly or substantially destroyed or damaged at any time.
by occurrence of any force majeure event. So if it is not destroyed or damaged, you
So
cannot.
according to you, the property remains that is it is. Then this clause.
Absolutely. Well, let's look into the contract. Look into the contract. I shall show your lordship the ballot, the other two, the two judgments of the Delhi High Court.
Because Delhi High Court there says that both.
Look into the contract also.
Yes, please show me that contract.
Yes, yes. Well, let first kindly come to 2020 SCC Online Delhi
2068.
2068.
Yes.
Yes.
Please show me the clause.
Well, let kindly come to the facts once. Kindly come to paragraph 4.
Yes.
Second page. The contract is quite detailed and runs into almost 1000 pages along with exhibits and annexures. Both the parties had filed extracts of the contract with their pleadings, and after judgment was reserved, the complete contract has been placed on record. The clause of the contract, as have been relied upon in oral and written submission, are only being considered for the present purpose due to the bulky nature of the contract. The relevant clauses relied upon in this judgment are appended to the judgment as Appendix A. Then, my lord, kindly come to paragraph 6.
It's an innovative way.
Sorry, my lord?
Judgment also contains an appendix.
Yes. Yes. No, I shall go to that one. It's in fact not necessary to go into that. Kindly come to paragraph 6.
Yes.
However, on 18th March 2020, the contractor invoked the force majeure clause and sought further time to complete the project. This was, however, not acceptable to the company, which on 31st March 2020 and again on 7th April 2020 invoked clause 11 proposing termination of the contract and threatened consequential action, including invocation of the bank guarantee. At that stage, the present petition was filed. On 13th April, the relief sought were restraint order from invoking the injunction. Then, my lord, if your lordship is pleased to come to paragraph 8, injunction ad interim injunction was granted. And I will show your lordship, after my lord detailed consideration on affidavit, that injunction was vacated here. But be that as it may, now kindly come to paragraph 63.
Yes.
It is under this factual backdrop that the ground of force majeure taken in March 2020 would have to be adjudged. The grounds taken to invoke the force majeure clause are that due to outbreak of COVID-19, experts from France who may be required cannot travel to India. Since the force majeure clause in the contract covers epidemics and pandemics, the contractor claims that its non-performance is justified and the invocation of the bank guarantee is liable to be stayed. There is no doubt that COVID-19 is a force majeure event, but was this event the cause of the non-performance? The law relating to force majeure has been recently settled by Supreme Court. Then, my lord, kindly come to paragraph 69. The question as to whether COVID-19 would justify non-performance or breach of a contract has to be examined on the facts and circumstances of each case. Every breach or non-performance cannot be justified or excused merely on the invocation of COVID-19 as a force majeure condition. The court would have to assess the conduct of the parties prior to the outbreak, the deadlines that were imposed in the contract, steps that were to be taken, the various compliances that were required to be made, and only then assess as to whether genuinely a party was prevented or is able to justify its non-performance due to the epidemic pandemic. Kindly pause here for a moment. There is no explanation of, my lord, the subsequent conduct.
Yes.
হ্যাঁ দেখলাম না না তার আগে একটা দেখালাম না Now kindly come to next paragraph 70.
Yes.
It is settled position in law that a force majeure clause is to be interpreted narrowly and not broadly. Parties ought to be compelled to adhere to contractual terms and conditions, and excusing non-performance would be only in exceptional situation. As observed in Energy Watchdog, it is not in the domain of courts to absolve parties from performing their part of the contract. It is also not the duty of courts to provide a shelter for justifying non-performance. There has to be a real reason and a real justification which the court would consider in order to invoke a force majeure clause. And my lord, here, my lord, your lordship was pleased to put a question whether, my lord, the business was running. And they said that, my lord, they were selling things. Percentage, nobody knows. Their stand was, I can show your lordship, their stand was from 20th or from this date, I shall give you 1% off, 2% off buying. Now, there was never, my lord, given any breakup that yes, this is the amount, this is this amount sold. No. Unilateral stand taken. And opportunities were repeatedly given. It's not that opportunity was not given. Now, my lord, the next decision, my lord, is 2022 SCC Online Delhi 1557.
That it was break up 50%, 50%.
Now, my lord, they have relied on paragraphs 42 onwards, my lord.
Yes.
42, 43, and 50 possibly they have relied on. Now, kindly come to paragraph 42, page 11.
Yes.
The law with regard to force majeure clause in contract and the provisions of the Indian Contract Act dealing with force majeure have been analyzed by the Supreme Court in Energy Watchdog versus Central Railway Regulatory, a coordinate bench of this court in Halberton Offshore Services in versus Vedanta. This is 2020, my lord, which I had placed with.
Yes.
They had relied on. Then, my lord, kindly turn the page 43. On the issue of whether or not COVID-19 pandemic would justify non-performance or breach of contract, the following observations were made in Halberton Supra. The question as to whether COVID-19 would justify non-performance or breach of a contract has to be examined on the facts and circumstances of each case. Every breach or non-performance cannot be justified or excused merely on the invocation of COVID-19 as a force majeure condition. The court would have to assess the conduct of the parties prior to the outbreak, the deadline that were imposed in the contract, the steps that were to be taken, the various compliances that were required to be made.
So that this has been set out from that judgment.
Then, my lord, kindly come to 48.
Yes.
Paragraph 48. Now I shall, 49. Clause 12 of the lease deed enumerates the various events of force majeure, that is, act of God, flood, earthquake, tempest, war, riot, embargo, etc. The use of the word etc. in clause 12 makes it clear that the said force majeure condition are illustrative and not exhaustive. Kindly pause here for a moment. That is not our clause. Our clause is very restrictive. If the building is damaged, destroyed, or substantially damaged. There was.
It's a tenancy matter. It's a tenancy matter and you are enjoying possession. And because contract and other things, if you are required to do certain things within a certain time.
That
then
is
extension-
different.
Then extension of time
Yes.
to perform your obligations.
That is different.
Here, you will be deprived of your right to possess if the property is destroyed or otherwise.
Yes, yes. Destroyed or
It's the right of
substantially.
possession which you are getting.
And you are continuing to enjoy.
So consideration is only for that.
Then kindly come to only one more paragraph, possibly. Paragraph 50. As noted above, the OM Office Memorandum dated 19th February 2020 recognizes the COVID-19 pandemic as an act of God. And this has been affirmed.
The government.
Yes, there, Delhi.
The central government, that notification during COVID-19.
That was possibly not of 19th February. That is subsequent.
That is probably of March.
That is possibly of March. Be that as it may. Office Memorandum.
But it has to be on COVID-19 onset
Yes.
because it recognizes that as an act of God. All right. So.
And this has been affirmed in the decision of this court in MEP Infrastructure Supra. In view of DDMA order dated 25th March 2020, an embargo was imposed on the operation of stops. Operation of shops
Which were not
selling essential commodities.
So that was only kept out of the purview.
The demised premises was not covered in the said exception and was therefore not operational. Therefore, in my view, the COVID-19 pandemic, to the extent that it resulted in the closure of the demised premises, would constitute a force majeure effect. Now, there is.
What was the force majeure here?
Yes.
What was the force majeure here?
Oh.
The clause.
The clause I'll show you.
Show me the.
Yes.
Because this was also a.
Kindly come to paragraph 49.
49.
Clause 12 of the lease deed enumerates the
49.
Yes, my lord. Page 14.
No, this, I think this is not the clause in that. Clause 12 of the lease deed.
Yes.
Where is that? Where is that?
Yes, my lord. Kindly come to page 10.
Page 10.
Yes. Part of paragraph 41, but.
All right. Post major. Yes, paragraph clause 12. Yes, yes. Neither party to hand over vacant possession of the diary. Neither party shall be liable. More or less similar, Mr. Mitro. This is 12.1.
Yes. In case the demised premises is destroyed, before that matter, neither party shall be liable to the other party for any delay or omission in the
I don't
performance.
think that may be relevant in possession.
Very well,
Part
12.1
12.1 may be.
In case the demised premises is destroyed or damaged by any act of God, such as fire, etc., they are becomes unfit for occupation, the term of the lease and rent payable by the lessee to the lessor shall be suspended till such time as the demised premises is once again rendered fit by the lessor at lessor's cost and expenses for occupation or use. However, if the repair or restoration activity is not completed within such and such, the lessee shall be at liberty to terminate the lease.
Your clause is different.
My clause is different. Office
Do it says destroyed or damaged.
Yes.
But
Rest is not. And my lord, they were carrying on the business. Not only, my lord, in 2020, 2021, even thereafter. And my lord, all the decision says, look into the conduct. The decisions which have been placed before your lordship speaks about the prior conduct because there was no question of considering the subsequent conduct. Here, look into the subsequent conduct. Now, my lord, as I have submitted before your lordship, that I could have understood that yes, they pay. The situation would have been completely different. Oh, and the other thing is, my lord, kindly come to the first paragraph of the this judgment 2022. Yes.
Which judgment?
This 20.
1557.
Yes.
Yes.
First paragraph. The present application has been filed on behalf of the plaintiff under Order 13A of the Civil Procedure Code as applicable to commercial suits seeking a summary judgment in favor of the plaintiff for a sum of rupees such. Only money claim. That is why, my lord, possibly the reliefs were given. Here, my lord, I say that no.
Eviction or forfeiture.
Well, those are
Anything more?
Lordship, I'll just indicate one thing, Lordship.
Reply.
Lordship, just 1 minute. Lordship, in the 2020 SCC Online Judgment 2068, which I had cited, in that it clearly lays down that the conduct of the parties has to be taken into account just right before. COVID-19 came in March 2020. If Lordship will see our conduct in February 2020, we were paying full rent at that time. Thereafter there were subsequently, my lord, we are not. Subsequently, my lord, we are not.
That is a subsequent conduct. That's after the situation became normal. Your conduct is. That's Mr. Mitro's subsequent.
I understand, Lordship. Lordship, just my submission is that
anybody going to airport, my lord, can see this property. Vishal Megamart is really Vishal.
Lordship, since February 20 and termination was made in September 2020. That was also in the middle of COVID, Lordship. Just that.
Already want to file any written notes?
Lordship, we can file written note.
If your lordship wants,
If your lordship wants, we'll file. Otherwise,
If you want, I do not want. If both of you want, I can fix date within which you can file it.
If your lordship wants, my lord.
if your lordship wants.
I do not
No,
want. If,
very well, my lord. In that event.
uh,
But may this file be tagged with my lord's
That
record.
I do not.